hearing for the inquiry into budget estimates 2022-2023. I acknowledge the Gadigal people of the Eora Nation, the traditional custodians on the lands on which we are meeting today. I pay my respects to elders past, present and emerging, and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the land and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today. I'll just take a moment. Mr. Borzak, the chair of the committee, is absent today. As deputy chair, I am chairing today's hearing, and Mr. Searle has been elected as the deputy chair. I welcome Attorney General Mark Speakman and accompanying officials to this hearing. Today, the committee will examine the proposed expenditure for the portfolio of Attorney General. Before we commence, I would like to make some brief comments about the procedures for today's hearing. Today's hearing is being broadcasted live via the Parliament's website. The proceedings are also being recorded, and a transcript will be placed on the committee's website when it becomes available. In accordance with the broadcasting guidelines, media representatives are reminded that they must take responsibility for what they publish about the committee's proceedings. All witnesses in budget estimates have a right to procedural fairness, according to the Procedural Fairness Resolution adopted by the House in 2018. There may be some questions that a witness could only answer if they had more time or with certain documents to hand. In these circumstances, witnesses are advised that they can take a question on notice and provide an answer within 21 days. If witnesses wish to hand up documents, they should do so through the committee staff. Attorney General, I remind you and the officers accompanying you that you are free to pass notes and refer directly to your advisors seated at the table behind you. Finally, could everyone please turn off their mobile phones or put them to silent for the duration of this hearing? So all witnesses will be sworn in prior to giving evidence. Attorney General Speakman, I remind you that you do not need to be sworn, as you have already sworn an oath to your office as a Member of Parliament. For all other witnesses, I ask that you each in turn state your full name, position, title and agency, swear an oath or an affirmation. The words of both the oath and affirmation are on the card on the table in front of you. If we could please begin with the first witness, Mr. McKnight, to my left.
My name is Paul McKnight. I'm the Deputy Secretary of Law Reform and Legal Services at the Department of Communities and Justice. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
I apologise if we would go back to my far left. Thank you, Ms. Boyd.
I'm Catherine Boyd, the Deputy Secretary General Counsel at the Department of Premier and Cabinet. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Ms. Smith.
Karen Smith, Crown Solicitor. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Mr. Tipple.
Michael Tipple, I'm Secretary of the Department of Communities and Justice. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Monique Hitter, Chief Executive Officer, Legal Aid New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Karen Wallace, Acting Deputy Secretary, Courts, Tribunal and Service Delivery, Department of Communities and Justice. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Hi, Anne Campbell, Acting Deputy Secretary, Strategy, Policy and Commissioning.
I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you all. Today's hearing will be conducted from 9:30 a.m. to 12:45 p.m. with a 15-minute break at 11 a.m. We are joined by the Attorney General in the morning, and in the afternoon we'll hear from departmental witnesses from 2 p.m. to 5:15 p.m. with a 15-minute break at 3:30 p.m. During these sessions there will be questions from the opposition and the crossbench members only. If required, an additional 15 minutes is allocated at the end of the morning and afternoon sessions for the government questions. Thank you very much for your attendance today. I can remind everybody that the microphones operate automatically, so you do not need to touch or switch on. Thank you for your attendance today, and we'll begin with questions from the opposition. Thank you.
Thank you, Chair. Welcome, Attorney, and to your officials.
Thank you.
Mr Attorney, it's been nearly 3 years since the LEC report in Operation Tusker was delivered. That was in October, which said that the Child Offenders Register was in need of urgent legislative change. It was overly complex. There had been a number of errors. 700 errors had been identified. Serious offenders were being left unmonitored to wander around the community. I think at least in one case they had reoffended. People who shouldn't have been on the register were and were subject to intrusive searches. 3 years on, nothing's been done about it. Your government was able to find John Barilaro a $500,000 a year job in New York. You did that pretty expeditiously. Why can't your government get its act together and fix this register?
Well, thanks for that question. There was a recommendation, a number of recommendations were made by LEC on that operation. They were primarily directed to the police force, and by and large those recommendations have been implemented. One recommendation was that I refer the question of legislative reform to the Law Reform Commission. Under Section 10 of the Law Reform Commission Act, substantive work by the Law Reform Commission depends on a reference by me. Where something falls within my portfolio responsibility, then I will be the substantive initiator of that reference. Where, however, something falls within the portfolio responsibility of another minister, then the substantive responsibility for developing a proposal is the responsibility of that minister. My role is effectively as a conduit or a gatekeeper to the Law Reform Commission, for example, to make sure that they're not getting references left, right and centre and can't take on the volume of work. In the case of that recommendation, there was a supplementary report by LEC last year, and Chapter 1 of that supplementary report deals with responses to that recommendation about a reference to the Law Reform Commission. So it's not something for which I have portfolio responsibility. It's a responsibility of the police force and ultimately the police minister. But LEC in the supplementary report noted that the police force agreed with the Commission that there is an urgent need for comprehensive reform of the legislation. In September 2019, the police force stated to the Commission that it supports legislative reform as a matter of urgency, but does not support referral to the Law Reform Commission. The police force advised that it has prepared its own proposal for a wholesale redraft of the Act, drawing on the Commission's analysis. It intends to consult with key stakeholders. And the police force stated that given LEC's extensive review, it's appropriate to approach government to seek legislative reform rather than a reference to the Law Reform Commission. That the police force then provided a draft of its proposals for reform in October 2019. In February 2020, Commission staff met with members of the police force. May 2020, the Commission wrote to the then Police and Emergency Services Minister, David Elliott, as the Minister responsible for the Act, seeking a response to Recommendation 3, interposing there. The Commission's writing to the Police Minister, it's not writing to me, saying where are things up to. The Minister replied in June 2020 and referred the Commission to the detailed review of the legislation being conducted by the police force. and the Minister informed the Commission that the police force had established an interagency working group and that the police force intends on closely consulting with LEC as the review progresses. There's then further references to toing and froing on that review. And then in March 2021, the police force confirms that it was pursuing revision of the Act and that its review of the Act was continuing, and that the police force will present recommendations for legislative change for government consideration at completion of the review. So it's not, certainly the police force acknowledges the deficiencies in the legislation. It's the portfolio responsibility of the Police Minister and the operational work of the police force at the moment to develop those proposals, which I understand are proceeding. But I might just add this, that where things, where matters relating to child abuse are within my portfolio, I think my record as Attorney General is as good as any in Australia in the last several years. We've acted very swiftly to implement the recommendations of the Royal Commission into Institutional Responses to Child Abuse. We adopted all the civil justice recommendations, including creating a proper defendant, a vicarious liability of institutions where someone was akin to an employee but not quite an employee, a proactive civil obligation to create safe places for children. We've adopted pretty much all the criminal justice recommendations, the first and most comprehensive response of any government in Australia. We were the first government to refer powers to the Commonwealth for the National Redress Scheme. With Victoria, we were the first of two governments to announce that we would be participating in a national redress scheme. We led the response of uniform evidence states on redrafting coincidence and tendency laws and presumptions in favour of joint trials. We've continued funding with the child sexual abuse evidence pilot in the District Court. Going beyond the Law Reform Commission recommendations, we have, in the civil liability space, reformed legislation so that claimants in relation to child sex abuse allegations can reopen settlements that are said to be unfair. So certainly where things are within my portfolio, I have been as proactive as any Attorney General in Australia. This, however, is not within my portfolio. I'm the gatekeeper of references to the Law Reform Commission. So I'd recommend that you follow those questions up with the Police Commissioner and the Police Minister when they appear before budget estimates.
Well, I will certainly do that, Mr. Attorney, but on the last occasion, I did ask you to perhaps confer with the Police Minister and to come back to us about a time frame when we might expect legislation. You took that on notice. Your answer on notice was to take it up with the Police Minister. Last year you said you hoped there would be legislation this year. That was still your optimistic hope in March. Can you now tell this committee what is your best estimate of legislation to fix these problems? Will it be in the last 5 sitting weeks of this Parliament?
Look, you'd have to ask the Police Minister that question. That's within his purview, and ask the Police Commissioner how their review is progressing.
Sure. Now, you've given us a bit of a timeline, a bit more of an insight into what's been happening within government. And previously, when I pressed you on these matters, you said that you thought there was better chance of cooperating with the police rather than referring it to the Law Reform Commission. But it has been 3 years and there's been no change. The Law Reform Commission can do pretty fast turnarounds if that's in the terms of reference. Should we interpret from what you've said that the hold-up is the Police Minister or police ministers?
No, look, it's not a matter of finger-pointing. It's a matter of identifying where you should ask your questions.
Sure.
And if there were a proposal to, if the police come back and say, no, we'd like it to be referred to the Law Reform Commission, then I'd certainly very closely consider that proposal as the ultimate gatekeeper of matters that go to the Law Reform Commission. But the police have undertaken very extensive work on this. They've undertaken very extensive consultation. I don't think that they've just put it in the too hard basket and forgotten about it. But you're best to ask the police commissioner and the police minister
Sure.
the prognosis for work in that area.
Well, rest assured I will do that. But on the last occasion here at Budget Estimates, you were very clear that the kinds of problems identified by the LEC were unacceptable. You agreed with the LEC assessment that this was urgent and pressing. Now, the police have been thinking about this matter for far longer than Operation Tusket was on foot. I know the legislation is said to be complex and unwieldy, leading to many errors, but the solution can't possibly be this difficult that it takes 3 years to not even have a proposal.
Yeah. Well, look, they're matters you should ask the police minister and the police commissioner about.
I note in the supplementary Operation Tusket report, the LEC did note the cooperation of the police, in particular Deputy Commissioner Hudson, but did say that it was still imperative that the Parliament substantially reform the Act as a matter of urgency because the mistakes that had occurred will keep occurring. I know you're not the portfolio minister, but you are the minister for the LEC, and you are the minister for the Law Reform Commission, and collectively you share the responsibility of the government's failure to act so far on this important matter. Surely there comes a point in time at which, as the first law officer, you'd have to at least propose to the police minister that some action be taken. Can you give us any insight into your thinking?
Well, look, as I said, it's the portfolio responsibility of the police minister. The police have been engaged in pretty extensive work on this over a few years. In terms of an ongoing reference to the Law Reform Commission, while the police accepted the need for urgent reform and LEC continued to identify that reform was urgent, there's no suggestion in the supplementary report that the LEC continues to consider that the Law Reform Commission reference is the appropriate vehicle for that. So that's on a reference to the Law Reform Commission. And in terms of drafting legislation, again, you are best to ask the police minister and the police commissioner about that.
Okay, well, I will do that. But are you saying that you, as first law officer, won't have any input into that process?
Well, I'll have input into that process. All cabinet.
Sorry, other than as a member of cabinet, as a matter of developing the framework or the solution, are you saying that you won't have any input into that?
When I see, when I see a draft, I will no doubt comment on that draft. But the responsibility for its development is within the portfolio of the police minister.
Okay. Last estimates, you said that periodically you do speak to the police minister about a range of matters, including this matter. Have you had any recent discussions with the police minister about the need to urgently act on this?
Not that I recall.
Okay. When you told Budget Estimates that you thought the Law Reform Commission option would have been too time consuming and that wasn't the best way forward, what discussions had you had or what advice had you received that led you to that view that the Law Reform Commission option wasn't the one likely to lead to the quickest and best outcome?
I'm not disputing your version of what I may have said at Budget Estimates. I don't recall saying that was my personal view, although it's possible that's what I said. But I may have been conveying the view or a government view rather than a personal view.
Understood.
But I think the police had objected to a reference to the Law Reform Commission on the basis they just thought it would take too long, and that hindsight's a wonderful thing, looking back. But at the time, they objected to it going to the Law Reform Commission because they thought their own review would be more expeditious.
But just on that, yes, the Law Reform Commission can take a long time to develop proposals, but if part of the reference included a time frame, they have done quick turnarounds in the past, haven't they, the Law Reform Commission?
Well, they can do that, and
in fact, you could have a temporary commissioner to sort of expeditiously lead a bespoke piece of work.
That's correct. And by way of example, I anticipate a very quick turnaround on the Bail Act reference that I made in the last week, because I'm keen to tidy that area.
But we'll come back to bail.
Yeah, okay. But I'm keen to tidy that up during this session of Parliament. So they can, but you can look back in hindsight and say, well, if it had gone to the Law Reform Commission 4 years ago, we would have had an answer. Hindsight is a wonderful thing, but at the time, the police considered, and the government didn't disagree, that the best prognosis for getting on with it in this area was for police to have carriage and to consult stakeholders.
And what were the discussions that you had that led you to believe that letting police manage this was without the assistance of the Law Reform Commission or your own administration, was the best outcome? Or was it just a sort of a police view that the government acquiesced in?
It was primarily firstly, it's within the it's not ultimately my decision to proactively put up a proposal for reference to the Law Reform Commission. If it's within my portfolio, that's my decision. If it's in someone else's portfolio, then I'm a conduit for that. I'm a gatekeeper for that to regulate the workflow, but I'm not the decision maker. And the decision that was made within the former police minister's office was that this was best to be handled by police. And
now, Mr. Attorney, I know that's
no one. I have not demurred from that decision.
Okay, but in the past, in the limited experience I've had as a staffer in the long distant past, when big issues are confronting government as a whole, sometimes the Attorney General is proactive and does take a proposal to other affected portfolio ministers, and there is interdepartmental discussions or interministerial discussions about how to solve this. Now, given the gravity of this matter, and I think you agree that this is a matter of some gravity, it's not acceptable, is it, to have sex offenders wandering around unsupervised? You accept that?
I accept that.
And it's also bad for people who shouldn't be on the register to be on the register.
Correct.
So you'd be keen to have this resolved.
Correct.
Hopefully this year.
Correct.
So in that case, why haven't you, given the drag of time that's taken, why haven't you taken the initiative to at least try and draw this process together?
Well, look, as I said, hindsight is a wonderful thing. Clearly, back in 2019, government did not anticipate that the matter would not have been resolved by now. I'd have to refresh my memory about what discussions I had in 2019 with the then police minister,
or even 2020 or 2021.
I'd have to refresh my memory on that.
Could you come back to us?
Yeah, sure. But primarily, the police minister at the time recommended that the police force conduct the review because they had the capacity and the expertise, and he thought that there would be a more expeditious and possibly informed outcome with that operational expertise than if the matter went to the Law Reform Commission.
Were you provided with any, in these discussions that led up to that sort of decision by the government, were you provided with any timeframes by the police minister about when he or his successor thought that this matter would be resolved?
I'd have to refresh my memory on that.
If you could and come back to us on notice, that would be really good. Since the time the government took that approach of leaving it with the police and the police minister, have you sought periodic updates from the police minister or his administration about this matter?
I have had periodic updates, I believe. I'd have to refresh my memory about when and how often, and I can't recall.
That's okay. It's not a gotcha.
To what extent I sought them or received them, but I have had periodic updates.
On notice, could you give us a narrative about what you sought, what you received, and when the most recent one was?
Sure.
That'll be really good. Now, so I will take it up with the police minister about whether or not we can expect legislation this year. But if we don't, what conclusions do you think the wider public should draw about this failure of government over a 3-year period to fix this problem?
That's a matter you should take up with the police minister and the police commissioner.
I will definitely do that. Thank you, Mr. Attorney. Did you want to start? We out of time?
Got 1 minute. Do you want to take it up? Or
You can start.
Shall I start? Okay. Well, thank you, Attorney. This may be your last budget estimates, particularly if you're going federal.
That's a point of order.
We have supplementary, surely.
I'll rule that's fine.
Attorney, can I just use that 1 minute to start off a conversation about the Crime Legislation Coercive Control Bill 2022
Sure.
and ask what was the reason for not having a time frame for commencement of this draft bill?
I'm not sure I understand your question.
What was the reason why it's a for not having a time frame for the commencement of this bill? According to the bill, this act commences on a day or days to be appointed by proclamation. There's no.
Sure. So I think there's a broad consensus among those who are proponents of coercive control criminalisation that there is a need for quite a long lead time between commencing the act on the one hand and assent on the other hand, and that lead time would have to be at least 12 months. That's because it's widely recognised that this is quite novel legislation. The way that police normally go about charging people is it's incident-based rather than a course of conduct. So it's a whole new way of thinking that will require considerable time to train police, to educate police, and also to raise general awareness about this offence in the public. The experience in jurisdictions which have introduced coercive control criminalisation in the last decade demonstrates the need for this long lead time of at least 12 months. That's been the suggestion was that in England and Wales there wasn't enough time to do this. Scotland took a much lengthier approach. And one of the issues I'm keen to get feedback in the consultation process is not only on the wording of the bill, but also how long stakeholders think we need before we commence the act. But at the moment, I would think we would need at least 12 months and maybe a bit longer. So that's. I hope that answers your question. That we haven't settled on a particular time frame, but I'd be expecting that there would be broad consensus that we would need at least 12 months.
Thank you. Okay, Mr. Attorney General. In early July, we saw the introduction of Section 22B into the Bail Act. And we know that the Premier committed that this sort of amendment would be made when he was speaking with a Ray Hadley on his radio interview show on the 15th of June. The Premier during that interview said words to the effect that you would introduce these amendments. Did you know he was going to make that commitment on that radio show?
Yes, I did.
Because he said that he would be speaking to you later that day, so clearly he'd spoken to you already.
So I had a conversation the previous evening with the Premier where we discussed an appropriate approach to issues that had arisen in recent bail decisions.
And that was directly in response to the, I suppose, the media kind of outcry around that?
Well, there was considerable community concern about the fact that some offenders who had been convicted of child sex offences had been granted bail pending sentencing. My understanding was that there had been a practice, pretty much a practice in the past, that in those circumstances, absent special, I'm not using this as a term of art like it might be in the legislation, but absent unusual circumstances, that when someone is convicted and it's pretty clear they're going to jail, that they would generally be refused bail. So there was community concern about that. And the Premier and I agreed that a legislative reform along the lines of what became Section 22B was an appropriate response.
And so then, does it concern you at all that it's, it's legislation that does engage in the prejudgment of a sentence, having kind of deep understanding that sentencing discretion is something that is fundamental to the proper operation. Judicial discretion is fundamental, particularly in sentencing. Does it concern you at all that really this is a form of prejudgment?
No, because I don't agree with that proposition that that's what it is. I mean, the second reading speech has made it very clear that we're not expecting judges, bail authorities, to make those kind of prejudgments. It's not a mini sentencing hearing. It's not a mini sentencing hearing, and it's comparable with what was already happening, where there was an appeal against conviction or sentence. That special circumstances or exceptional circumstances would have to be demonstrated for a detention application not to succeed. Section 18 of the Bail Act already requires a consideration of the likelihood of a custodial sentence. So this is not determining definitively what is going to happen. So that doesn't concern me at all. And it's something, as I say, with Section 18 that to which courts would already advert in making a bail determination.
So even the words will be sentenced to imprisonment, you're suggesting that that's not asking for a predetermination. Will be sentenced to imprisonment. That's the term upon which the law operates.
It's making a finding for the purpose of the detention or bail application. It's not making a finding that binds a judge down the track in any way in actual sentencing. But in any bail decision, absent 22B, there's a requirement to weigh up various factors, including the likelihood of a custodial sentence if convicted. So this was already a matter that a bail authority had to take into account. What has changed is the standard of likelihood, if you like, as well as now a carve-out for special or exceptional circumstances.
Sounding very much like a prejudgment there, Attorney. I mean, if you're suggesting that there was already a requirement to do that kind of investigation in the exercise of discretion in a application, then the words will be sentenced to imprisonment does seem to take it that bit further.
Well, I'd make two comments in response to that. Firstly, until these cases emerged, at least in times gone past, there was as I understand it, there was a general, having spoken to some judicial officers, there was a general practice to refuse bail in these circumstances. And secondly, if you are looking under Section 18 at the likelihood of a custodial sentence, the court is already making a determination for the purposes of a bail or detention application only of whether or not someone is going to be incarcerated.
So do you accept the views of the expert views of the Law Society, the ALS and the Bar Association that it was perhaps the amendments were rushed and that they may have unintended consequences and that they may in fact disproportionately impact unintended defendants?
What do you mean by unintended defendants?
Well, do you accept the views, particularly of those organisations, that these amendments may in fact interfere with the very good system that you introduced, the early appropriate guilty plea program, particularly in relation to the special and exceptional circumstances test, and that in fact this new provision may deter or may affect the operation of that scheme?
Sure. No doubt, in terms of your suggestion, it was rushed. I don't think it was rushed, but it was certainly dealt with urgently. It was put through both houses as a matter of urgency. So I certainly accept that it was dealt with urgently. On the question of the impact on early appropriate guilty pleas, we have said we will keep that under review. But I'll make a couple of points. One is I don't anticipate an increase in the incarceration rate because of these reforms. The purpose of these reforms is not ultimately to put more people in jail. It will bring forward the incarceration of those who the courts expect will be going to jail in any event. So rather than, if there's a 4-month delay between conviction and sentence and there's an expectation they're going to jail, rather than that incarceration start in 4 months' time, it will start straight away, and time served will generally be credited in the ultimate sentence. So it won't increase. I don't anticipate will increase the overall rate of incarceration. So far as the impact on early appropriate guilty pleas is concerned, we have said we will monitor that very closely. But my current anticipation is that it won't negatively impact the operation of that scheme. Those who plead before committal get a fixed, with some exceptions, largely get a 25% discount. And then there are further discounts the later you have. So they are big incentives for an early appropriate guilty plea. If someone if you expect someone is going to go to jail, you would expect they have legal advice to that effect. So the effect of what we're doing is to bring forward their incarceration, not to increase it. Now, maybe some people might say, well, I've got to I've got to get my kids organised or my elderly parent organised, and I don't, I know I'm going to go to jail, but I don't want to go to straight away. And if I have to plead guilty, that's going to happen straight away when I won't do it. Well, that's dealt with by having a special or exceptional circumstances carve out. So if there are people with unusual circumstances that justify starting the service of incarceration later on, then that's covered there. So I understand the critique. That's why we will closely monitor the statistics, but my present anticipation is that there won't be any material adverse impact on the operation of that scheme.
Is that just a hunch, or when you say it wasn't, the amendments weren't rushed, that they were done urgently, it's not my view alone. It's those agencies and those expert frontline law services that you didn't consult with, you didn't talk to, nobody spoke to them. They believe and spoke very publicly that they would have had material, substantive material to present to suggest that these laws will see a change and will see an increase in incarceration on remand, and that there is a significant difference between remand and custodial sentence, and that clearly these things perhaps have not been factored in properly. And perhaps going to the ALS point, which I think is resoundingly one that you need to take clear and firm responsibility for, and that is the disproportionate impact that this may have on First Nations people, and whether or not there is regret or again, with the benefit of hindsight. But, how can you say that it's not going to have an increase or that we're not going to experience an increase when you didn't seek any input, you haven't had those expert views put in front of you, and they, in fact, say otherwise?
Well, there are a number of propositions that you've just put. Firstly, in terms of consultation, we did consult the Law Society. We did consult the Bar Association, albeit in truncated and urgent circumstances. We did not consult the ALS, and I have apologised to the ALS for that. I don't anticipate a disproportionate impact on First Nations people because I don't anticipate an increase in the overall rate of incarceration for the reasons I've given. You said, is it a hunch? No, it's not a hunch. It's a reasoned approach from first principles that I've attempted to articulate. If you are sending to jail in a bail or detention application someone the court expects is going to go to jail anyway, you are not increasing the overall rate of incarceration. You are bringing forward incarceration that is going to happen anyway. So I don't anticipate an adverse impact on First Nations people because I don't anticipate an increase in the overall rate of incarceration.
Do you accept that there is a difference between remand and custodial sentence incarceration?
In the sense that a sentence is punishment for an offence that has been found. Remand is not punishment. Remand is a holding position where, balancing all considerations, the court keeps someone in detention.
In the New South Wales government's $143 million investment towards zero suicides in New South Wales, one of the priorities in that for suicide prevention spoke of remand being a significant risk factor for suicide. Does increasing the remand, which I think you're suggesting we are going to do by bringing forward incarceration, do you think that we've got a problem there and that we're running counter to even in a specific way, that this is again something we didn't anticipate?
Look, other things being equal, there is a risk with any incarceration of mental health issues and sadly suicide. I don't have in front of me the passage to which you quote. I suspect that is comparing, that would be comparing remand with being on bail. But the point here is you are not increasing. I don't anticipate that you are increasing the overall rate of incarceration, and therefore the risk of suicide inside a prison by these reforms. So the risk with remand is the risk of suicide inside a jail. You are not increasing that risk if what you are doing is bringing forward incarceration rather than increasing the rate of incarceration. And if there are special or exceptional circumstances affecting that individual, which may be, for example, the need for particular medical treatment that can't be provided inside a prison, then that's a special or exceptional circumstance that could be made out on the facts before a bail authority.
So you're aware of cases where a magistrate or a judge who, based on police facts and the criminal history and the hearing, initially forms the view that a full-time custodial sentence is warranted, but that view will change, and that view can change on the consideration of subjective material presented during a sentence hearing. But on your new version of our law, where we've predetermined that somebody will be sentenced to imprisonment and they're denied bail and they're incarcerated, then they were incarcerated wrongly, ultimately.
I don't anticipate any material increase in those sort of circumstances. If, as was said in the second reading speech in the Legislative Council, if there's a possibility that someone will not be incarcerated, then Section 22B is not invoked, and you go to general bail principles. So I don't accept, I don't anticipate a materially increased risk of that happening.
And do you see that that the difference, one fundamental difference, will be that defendants will not be able to access the rehabilitation and reform programs that they may have otherwise between guilt and sentence?
Well, that is an issue. But that's something corrective services can look at. What sort of high intensity programs would be appropriate for people on remand? So we do have HIPOs. I think it's the acronym. High intensity units providing short rehabilitation programs for people who are on remand or short sentences, including domestic violence offenders. I think there are variants of those in-prison programs specifically aimed at domestic violence offenders.
Just finally, when you your commitment that you will be monitoring the impacts, what sort of monitoring program have you set up?
Do you want to comment on that? I'll ask Mr. McKnight to answer that.
Thank you.
In terms of the EAGP effects, is that where your question is going?
Yeah, and also perhaps if there is monitoring overall in terms of the not hunches that you said that you've based the laws upon.
Exactly. So the effects of these reforms will be monitored through the Bail Act Monitoring Group, which receives reports on how the Bail Act is working on the ground. In terms of the effect on the early appropriate guilty pleas legislation, there's an early appropriate guilty pleas steering committee that the Chief District Court Judge chairs, and that committee will get reports on the effect. There's also the criminal justice the Criminal Justice Reform Board, which the Secretary chairs, which receives regular reports on a wide range of matters that affect the criminal justice system, including bail rates, remand rates, and the effects, the performance of the courts. So all of those bodies will be looking at the effects of these reforms and all the other reforms that go through the criminal justice system.
Thank you. So just to finish, Mr. Attorney, if the monitoring does suggest that these laws, these amendments are not working as intended, would you consider, assuming you're still there, to repeal those laws?
Well, look, there's no point monitoring something without intending to act on the results of the monitoring, but I can't answer in the abstract what the response might be without knowing what the monitoring produces. But that's the whole, we're not locked into a position if the facts change.
Thank you. Right, we're back to
Thank you, Chair. Just go back to my questions, and thank you, Attorney. Just continuing with the Crimes Legislation Coercion Control Bill, you've chosen clearly that this Act commences on a day or days to be appointed by proclamation. Are there any conditions that needs to be met between now and the proclamation date?
No, but I'm happy to enter rather than being the discretion. So when it commences on proclamation, that effectively gives the executive a discretion,
Right.
To make a recommendation to the governor to proclaim proclaim operation. I'm happy to entertain, if that's what stakeholders think appropriate, something in the draft that says it will be at a date to be proclaimed in a certain date range, so that people have comfort that it's not going to be pushed off to the never. And on the other hand, they have comfort that it's not going to be done too hastily. So that's a draft bill. It's a draft because I want comments and feedback like that. And if that gives people some comfort that it's definitely going to happen, but it won't happen too quickly, then I'm happy to put a range of dates within which a proclamation would be. I'm happy to be able to be a matter for Cabinet, but personally I'm happy to recommend that there be a date range there if that's what makes people feel comfortable.
Yeah, so certainly there are some concerns about that, Attorney, particularly because we've had experiences in the past where we've had legislation, in particular the New South Wales Modern Slavery Act in 2018, which was also to commence by proclamation, and it took 1,284 days after royal assent for the Act to commence. Well, that's a long time. Yeah. There's no clarity in this proposed draft for people to understand when things will start and kick off.
Sure. Well, I think the Modern Slavery Act was a fairly peculiar set of circumstances because you had intervening federal legislation in that time, and the question was, and some difficulties in operationalising what was in the Modern Slavery Act 2018, and eventually that was resolved in legislation that commenced this year. But as I say, if I haven't received any, doesn't mean my office hasn't or the government hasn't, but I'm not aware of any feedback of concern about that drafting of the commencement date in our exposure draft for coercive control. But I'm certainly, I'd be favourably inclined to any date by which it must happen and date before which it can't happen. To give, for example, we might say it will be a date to be proclaimed, but it mustn't be any later than, to pull a date out of the air, 1 July 23, and it mustn't be any sooner than 1 January 23.
Why wasn't it done that way?
Or sorry, 24, I should say.
Why wasn't it done that way instead of a proclamation?
Well, it's pretty unusual. That sort of range is pretty unusual. But as I say, it's no one has complained to me about it yet, but I'm certainly happy to put in start and finish dates for any range within which it's proclaimed.
So in terms of
the general, almost unanimous feedback is this is not something that should commence on assent. It's something where you need at least 12 months to train the judiciary, to train the police force, to raise community awareness, to assist and empower frontline workers before the legislation starts.
So in terms of time frame, so do you anticipate between royal assent and commencement it will commence, it will kick off?
Well, my aim is to have legislation through Parliament this year, and then I guess that means...
Only 5 weeks left.
5 or 6.
5 sitting weeks.
Six sitting weeks. We announced at the end of last year that we intended to bring legislation in this session. If that legislation is passed, then I would anticipate it wouldn't commence for at least 12 months. But if stakeholders tell us, no, it should commence sooner, then that's certainly something we'll take into account. But I don't expect to get that sort of submission.
Well, stakeholders have
contrary.
different interpretations of various things, which I'll come to in a minute. But firstly, Attorney, can I ask you in terms of the training of New South Wales Police when this legislation goes through, what is the current proposal for specialised training to New South Wales Police? Is there a proposal? What proposals do you have?
You have to with that matter for police. Yeah, I think we're working on that, and that's also something that we'll be doing jointly with police.
Because that's clearly a critical aspect of this whole legislation. The police have to be well trained to be able to execute this particular legislation and understand this specific legislation. Wouldn't you say so, Attorney?
That's correct. But you can't train them until the legislation is finalised. And that's again why you would need at least 12 months of my current advice before the legislation commenced. Because the experience in England and Wales has been a tendency not to use this charge initially because of lack of training of police and their unfamiliarity with it. So I agree, it is a critical part of the success of any such legislation.
After proclamation, then there's 12 months of commencement. Then after 12 months, you will start training?
No, that's what the 12 months is for. The 12 months is to train, or whatever figure we settle on, but say it's 12 months, to train police, to get the bench books in place, to educate the judiciary, to raise community awareness, because, quite frankly, I think it's possible the majority of the community have never heard of coercive control, don't know what it is. Victim survivors don't understand that they're the victims of coercive control as distinct from separate physical abuse. So raising that awareness is not going to be something that happens between it going through both houses and assent. That's why I suspect you need at least 12 months to do that. So that is what is happening in that 12 months. We're not doing a standing start 12 months later.
The reason I raise that concern is that clearly there's been reports in the papers, one in the Sydney Morning Herald titled "Lack of Police Training Could Stymie Success of Coercive Control Laws." I mean, clearly they're raising this issue now, not raising it in 6 months' time once the law is proclaimed.
That's right. Well, I completely accept that, and that's why the legislation won't start on assent. It will start on a date to be proclaimed, which my current expectation would be is at least 12 months. And as I said, if to give people some comfort that it's definitely going to happen and not be archived somewhere, I'm happy to put a finished date on that. And if people want to make sure it's not too rushed because of the need for, among other things, police training, a not before marking.
Do we have any understanding as to how many officers and staff will be provided training?
I'd have to take that on notice. I'd have to take that
Because
on notice.
as I understand it, Attorney, you wanted to get this legislation through pretty quickly. Obviously, this would have been something on top of your mind as to the number of police officers and staff that ought to be trained to be able to execute this particular legislation.
Well, when you say get it through quickly, I want to get it through promptly this year because we know that coercive control is a precursor to just about every intimate partner domestic violence homicide in New South Wales. The DVDRT report suggested that in 99% of intimate partner domestic violence homicides in New South Wales over a 6 or 8 year period, 99% of them have been preceded by coercive control. So the longer we wait, the more lives we put at risk. So I do want to do it promptly, but in terms of if there's an implication in your question that this is being rushed, that's not the case. We've had a discussion paper out now for almost 2 years. We had a joint select committee that unanimously recommended criminalisation. It took, I think, 150 written submissions when they were submissions were open for over an 11-week period. Heard from 70 witnesses, had 6 days of hearing. Before this exposure draft, we consulted legal stakeholders, the police, the Aboriginal Legal Service, before this draft went out. So this is not rushed. This has been a thorough and methodical process, drawing on the learnings of other jurisdictions like England and Wales and Scotland.
I'll come to those
But what
questions.
can't be rushed is that once the legislation commences, the training of police, the training of the judiciary, and raising general community awareness.
I'll come to those particular points, Attorney. But first, staying on police, will training be mandatory to police across New South Wales?
That hasn't been determined, to my knowledge. That will probably be a matter for the police commissioner and the police, but I hope to have some input into that. We know that maybe up to half the volume of work of general duties officers in the police force is domestic violence. Given though the unusual, I expect that all police officers will have to be trained in it to some extent, but operationally, who will have the responsibility for bringing prosecutions, whether it's a matter for general duties officers or a more specialised squad, is yet to be determined. But we will want to draw, I imagine, on learnings from Scotland and England and Wales of what works and hasn't worked in those jurisdictions.
And in terms of dollar terms, do you have any idea as to how much will be allocated for police training? I know you just said that you haven't cast your mind across how many police.
No, I don't. So I don't think a final allocation has not been made. There was around 700,000, I think, in the budget, but that you could regard that as a down payment.
700,000.
$700,000
right across New South Wales.
That's an initial contribution in the budget for 22-23.
So you anticipate there will be a larger contribution down the track?
Well, when we get a budget proposal worked up, that's my present expectation.
Because clearly 700,000 is a small amount.
That will go a fair way, but my
legislation.
anticipation is there'll be a budget proposal for more.
When Shoebridge is here, we always ask questions in particular about the increased number of incarcerations amongst our First Nations people. What mechanisms are in place to ensure that this new offence does not further contribute to the crisis of Indigenous incarceration in New South Wales?
Sure. I don't know that...
Because it'll certainly capture, given the significance of domestic violence in our communities, it'll certainly capture that aspect within our First Nations people?
Look, I'm very conscious of that issue, and I know that many Indigenous stakeholders and the Aboriginal Legal Service have opposed the criminalisation of coercive control because they fear, obviously, if you're going to have a crime on the books, people are going to be charged, people are going to be convicted, people are going to be incarcerated. So that is something that I'm very alive to. One of the issues that has concerned some stakeholders is reverse criminalisation, the failure to identify who is the perpetrator and who is the victim. I don't know that, but again, this is why we've got an exposure draft out to get comments on that. I don't know that drafting the legislation is going to solve that problem. What will address that problem, I think, will be training of police officers to identify these sort of circumstances, which again is why it's so important to have a significant lead time between legislation going through and commencing legislation. One of the purposes of criminalisation as well is to raise awareness of coercive control. I mean, I have to be honest with you. When I became Attorney General, I'd never heard of coercive control. I didn't know what it was. I suspect most people in the community don't know what it was, and as I said earlier, I suspect a lot of victim survivors don't realise this. But one purpose of criminal law is to change behaviour. It's not just to capture people and charge people and send them to jail. It's to change behaviour as well. So a lengthy education program and awareness raising program as well is part of mitigating the risk that you identify.
Attorney, I'll come back to the length of time of your draft exposure and the consultation process that you're currently undertaking. But first of all, can I, given that you've mentioned a number of times the Northern Ireland, the Irish and the Scottish experiences, can I ask, in terms of the Northern Irish legislation on coercive control, it takes a broad and unique scope, extent of relationships, as opposed to what you're currently having. It covers moving beyond intimate partners to include members of the same family and members of the partner's family. Why was the decision made not to follow this approach, given that you've obviously used the Irish model as well?
We've looked at various models. The Scottish model is sometimes said to be a gold standard. It is limited to former and current intimate partners. It doesn't extend to other domestic relationships. Evan Stark was the sociologist who started this analysis of this phenomenon of coercive control, and it is largely a dynamic within intimate partner relationships. It is a different dynamic from child abuse or elder abuse, for example. So it might be further down the track that we would look at expanding the scope of this legislation, but this is a very significant change to the criminal law. So my approach is to be cautious and incremental, to try to get the balance right between capturing obnoxious and abusive conduct on the one hand, but not overly or inadvertently criminalising behaviour on the other hand that shouldn't attract the sanction of the criminal law. So this is part of getting that balance right. But what is said to be the gold standard in Scotland does not extend this legislation beyond intimate partner relationships, where the sociological evidence and analysis suggests that overwhelmingly it's a dynamic in that context rather than in other domestic relationships.
I mean, I wasn't part of the process, but were there feedback to you and through the various consultation process that said that this ought to be looked at?
Yes. Look. There will be stakeholders who say it should be broader than intimate partner relationships. I accept that. There will be others who may say it should be limited in the way that we propose.
So your view is that it should be limited?
Look, that's the current view. This, as I say, this is a significant change to criminal law by focusing on courses of conduct rather than individual incidents. I mean, there's also the issue you've raised of Indigenous overrepresentation in a criminal justice system. Were you to go broader than intimate partner relationships, you would pick up kinship groups, for example, which some suggest we should do. But again, that's trying to balance the need to protect those at risk on the one hand with avoiding over-criminalisation on the other hand. Having this limit to intimate partner relationships is part of that, including considering the impact on Indigenous communities.
Yeah, it certainly has impacts in many ways in various communities. I mean, I don't know whether, in terms of the multicultural communities, whether they've had significant understanding or interaction with this, whether that consultation process had included CALD communities. I mean, I haven't seen it, for example, in the Arabic media, that there's this particular legislation, coercive control, coming through. You indicated, as I would say the same, that I wouldn't have known what it was initially until I read on this. Communities out there would not know what this coercive control is. So in terms of the consultation process, has it reached out to those CALD communities?
Well, I believe the Joint Select Committee certainly did, and I can refer you to the list of stakeholders who provided submissions and gave evidence at the hearing, but they included CALD stakeholders. I'll let you look at that list but if you want to, I can provide it.
Sure.
During the consultation period that's open at the moment, as well as inviting members of the public to provide submissions on the Have Yours Say website, the Department of Communities and Justice has organised a series of targeted roundtables, so I think about 10 roundtables. And
Have they commenced?
They're in the process at the moment, and I think at least one of those is a CALD roundtable. I'll invite Mr McKnight to address that.
So the department is currently undertaking targeted consultations, as the attorney said. So far there have been 10 targeted consultations, so those are either targeted meetings or roundtables, and a further 10 are planned before the 31st of August. I can tell you that one of those roundtables was targeting the culturally and linguistically diverse community. We've also targeted legal stakeholders. We've targeted the domestic and family violence sector. Aboriginal women have had a specific roundtable. There's been a roundtable with the LGBTQIA+ sector. Tomorrow there will be roundtables targeting groups representing older people and the disability sector. Toward the end of August, there will be 2 regional visits, mostly to target Aboriginal groups in Kempsey and Dubbo, but I think there was a legal stakeholder roundtable also planned in Dubbo. So we're very active talking to people about this legislation.
And the CALD community that you're targeting, has that meeting happened?
It has. It happened on the 10th of August.
And what was it, a broad cross-section of CALD community presence?
I would have to take on notice who was represented at that meeting. My note doesn't cover the detail of who was there. But it would have been as broad as we could accommodate to ensure that the representation was broad for that community. Yeah.
Thank you. Attorney General, I would like to now talk to you about the children, if that's okay, and in particular, I know that through the meeting of Attorneys General, you were leading and mapping out an attempt to harmonise the raising the age of criminal responsibility, and clearly that's not worked for all sorts of various reasons, or I'm sure you have a different version of work here. But I suppose what I'm trying to say is that we've seen the ACT and the Northern Territory, they are forging, they're taking their path. And I know that week before last, you were presented with the 63,488 signature petition, of which I was also presented that. And of course, the people who presented that to us, the coalition there, the Alliance, basically said that they would have got thousands and thousands of more signatures, but they literally cut it off in the absolute hope that now was a timely and appropriate time to present it with you before we head to the state election, giving you this one more chance to actually take to action and raise the age and do something for our children when, as you and I both know, the evidence is just overwhelming that what we're doing right now is not right.
Is there a question?
The question is, are you going to do it? And the question really is, where are you up to, Attorney General? Because, as you know, there are people so stressed on this question, and they're urging us all in this place to do something, Attorney.
Well, look, I'm very grateful to all legal and medical stakeholders who've worked very hard on this. The Attorneys General across the country met in Melbourne on the 12th of August. We had previously agreed in November last year that state attorneys general would develop a proposal to go to 12 and give consideration to carve-outs, if any. That has now been overtaken by what we agreed on the 12th of August, which we would continue to work to develop a proposal to increase the minimum age, paying particular attention to eliminating the overrepresentation of First Nations children in the criminal justice system. So that work is back on track. I anticipate it will come to a head probably the middle of next year. I can't preempt what it may or may not decide or preempt what New South Wales may or may not do. But our present position is we're part of that national process, trying to find common ground among the states, accepting that the ACT and the Northern Territory have already announced what they're going to do. In the case of the ACT, go to 14. In the case of the Northern Territory, go to 12.
I think
can I just add one other thing? One. I mean, ultimately, this has to be what is the best way to protect community safety. And proponents of going to 14 or raising the age would say you will have a safer community if you avoid early engagement with the criminal justice system. But if you're going to do that, you need, rather than do this in the abstract, you need to identify what is the alternative pathway for offenders under 14 or 12 or whatever age you have. That is what I hope this working group will do, because when a proposal is developed, it will be really important to identify what is the alternative pathway, so that it's not a retreat. It's not a retreat from intervention, but it's something that we think will be a better model. Now, I know the ACT is doing work on that, and hopefully that will inform a decision that state attorneys general, state governments and New South Wales come to. But that is a really important part of the process, and hitherto, I think where it has stalled at a national level is that work has not been done.
So you referring there, Attorney, to the ACT report, the review of the service system and implementation requirements for raising the minimum age?
That's something we'll look at. But
is that something you would commit to doing here and having that same kind of
No, I can't commit to anything because the government here has not made any decision.
How can we introduce bail laws after one radio announcement and 5 weeks, and we can't introduce laws that are actually going to not only meet community expectation but save children's lives?
Well, we have been relying on a national process, and we've been relying on that national process to develop an alternative model, so we can then consider is that alternative model the way to go. That national process led by Western Australia has not reached that point, and that's what we're relying on. I mean, and the way the meetings of Attorney General work is different jurisdictions take the lead responsibility for different projects. So New South Wales, for example, has been the lead jurisdiction on defamation and on access to digital assets after death and incapacity. We have not been the lead jurisdiction on raising the minimum age. That has been Western Australia. So we're reliant on Western Australia leading that project. I think Queensland is now joining them, and I think the Commonwealth are joining them as well. So I think there are three. Can I have liberty to apply if I've misidentified which jurisdictions are doing it? But I think it's Queensland, WA, and the Commonwealth are now leading the work in this area to develop a proposal.
Why are we so committed, Attorney General? If we think that we should be raising the age, why are we so committed to the harmonisation project that clearly other states and territories have now
When you
left?
say we think, you think, the government hasn't reached a view because rather than developing our own alternative pathways, we've been relying on a national process to do that, so we can then evaluate that alternative pathway. Hang on, I haven't finished. Sorry. So we can then evaluate that alternative pathway and decide whether that represents an improved model of community safety and avoidance of offending and reoffending than the status quo. So it's not that we have done nothing. We've been relying on a national process that has stalled in the last 12 months, but I'm confident as a result of the discussions I've had with other Attorneys General on the 12th of August, that is now reinvigorated, and we should have some concrete proposal to consider around the middle of next year.
The communique is quite vague and disappointing, really. It really does just say we commit to carrying on this, or we commit to keeping on looking at it, I think, or something to that effect. So at this point, am I hearing clearly that you're not committing to forge away and take New South Wales on its own path of raising the age, particular to our circumstances here in New South Wales?
I can't predict what New South Wales will do from the middle of next year. But I don't anticipate us doing our own thing this side of the reinvigorated attempt at a national approach.
But do you accept that really the harmonisation and this approach, the national process that you were committed to, has failed? And I'm not just trying to be silly there. I'm suggesting we've got now evidence of others not being part of that and forging their own path and going forward.
No, I don't accept that. I accept that it has stalled, but I think it is reinvigorated. I think harmonisation is desirable, but it's not essential in criminal law. There are some areas of the law, like defamation, where it's ludicrous for different jurisdictions to do different things because...
It's hardly a comparison. We're talking about locking children
I haven't
up.
finished. I haven't finished. Let me finish. Where it's clearly ludicrous for different state and territory jurisdictions to do different things when a wrongdoing can cross borders. It's not essential that in the criminal law that each state and territory jurisdiction operate in unison. It is desirable, and it's desirable that we learn from each other and cross-fertilise ideas and learnings and research, which is what we're attempting to do with this approach. So I don't accept that it has failed. I accept that it has stalled, but I think it is reinvigorated, and the New South Wales approach at the moment is to see what this produces.
But not before mid-next year?
Well, I don't anticipate anything substantial before in, for example, this session of Parliament. but it's not in the too hard basket. I mean, it is a on one view a contentious area. It's not in the too hard basket, but if there is a national model, if you like, being developed with research and, more importantly, developing what would be an alternative pathway, that's something we would want to look at before deciding what we do.
And so what resources are we putting into that at the moment?
I'll let Mr. McKnight supplement, but we're on a working group, I think, but primarily, as I said before, at the meetings of Attorney General, different jurisdictions take lead responsibility. So we are not the lead jurisdiction doing this, but Mr. McKnight?
Yeah, and basically we're participating in the National Working Group.
Do you think we should be stepping up our efforts? I mean, if it's stalled and we've recommitted, do we really have to wait for other states? Can we not take lead in your own agency to do something that is so desperately wanted by so many of the experts and so many people across our community? It's our children. It's not adults ruining each other's reputations. Yep. This is about our children being incarcerated. And the number we know of children in incarceration between 10 and 14 is actually not that great in terms of the volume, the quantity of people. But every single one is dire, it's significant, and it's having catastrophic impacts, not just on their lives, on everybody's lives. Do you not think we should perhaps unstall the process, take some leadership and do something here in New South Wales?
Well, it's not just about the children under 14, it's also about those who are harmed by their actions, which is why it is important that if there is any move to raise the minimum age of criminal responsibility, we have a very clear idea about what the alternative pathway is. So we are being proactive on that in the sense that we are facilitating a national process that will develop an alternative pathway, and we are cooperating with another jurisdiction or jurisdictions that are taking that lead. But we don't intend to run our own parallel process when there is that national process that every jurisdiction is cooperating with happening at the moment, which in my read of what happened on the 12th of August, having stalled, is now reinvigorated.
Do we think, just finally, do we think that the work that the ACT did in reviewing the services and all those wraparound processes and diversionary programs that are necessary, is that not something that we should be doing now here in New South Wales so that in the event we get some national leadership through MAGs and we take a harmonisation process, won't we need to have done this work for when that time comes and we're ready and we've got a system that is fit and proper and ready to go?
Correct, and that's why there is a national process to do that work that another jurisdiction is leading, and I would anticipate that whatever the ACT is doing will be taken into account in developing that. But that's why that's what this national process is for.
And it will
to develop
specifically New South Wales analysis. Is that what you're saying?
Well, there might be a. Do you want to comment on that? Whether we're New South Wales?
I mean, the working group hasn't reconvened post the meeting of Attorneys General, so I would anticipate that the scope of work that the working group sets up would cover cataloguing existing services and service gaps on a national basis, given the kind of work that the Attorney General's agreed to do, and should that be the case, New South Wales will participate in that process.
Right. Thank you.
You're welcome. Thank you.
Okay. Yeah. What would you like to do with morning tea in 13 minutes? Do you want to more 7 minutes? Sorry.
We'll keep going for morning tea time.
Terrific. Over to you.
Yep. So, Chair, I'll just clarify. We'll have recess at 11.
Correct.
We will,
yeah.
but we'll just go to some more opposition questions.
Thank you.
Unfortunately, not an early morning tea break just yet.
Thank you.
All right. Oh, thank you again, Madam Chair. I'll just continue my questions with regards to the coercive control questions. You've indicated, Attorney, that Scotland model is a gold standard.
I haven't said it's the gold standard. I said that's what some others say it is.
I thought you said that, but that's okay.
I don't think I did. But yeah.
Okay, that's fair enough. Well, my question here then is that the draft bill uses the phrase course of conduct. Why was the decision made to not include a specific number of instances? Both Scotland and Northern Ireland refers to at least two occasions.
Well, the wording of our exposure draft leaves it open that two occasions could constitute a course of conduct, but we don't want to be overly prescriptive. The thinking behind the current draft, and again, it's a draft, is that we don't want to be overly prescriptive and say that what on one view might be merely two occasions constitutes a course of conduct.
When you say, I think it's a course of conduct, like a regular, as opposed to not just one or two events. Would that be an interpretation that some might see as being not one or two may not be a course of conduct, but a more of a series of 3, 4, 5, 6 is a course of conduct. A series of them will constitute a course of conduct.
There are plenty of instances in the law, including the criminal law, where you don't have some kind of quantitative standard for what falls within the offence. So take an expression like negligence. That's a finding of fact as to whether something constitutes negligence. Likewise, whether something happens often enough or of a kind of particular kind that it constitutes a course of conduct, that's for a magistrate or a jury to determine. And the fact that judgment has to be made about whether something does or doesn't fall within a description doesn't mean it's inappropriate.
So in other words, two occasions is a course of conduct.
Well, it may be. It would be open to a jury or a magistrate to find that two are, but it would also, I think on that drafting, be open to find that two was not enough.
But Mr. Attorney, I mean, this is a novel piece of legislation, you've said in the past, and you've spoken about the difficulties of trying to regulate coercive control as a new concept. Wouldn't it be better to be clearer rather than run the risk that courts in interpreting this may not apply it as you intend?
You want to be clear, but you also want to avoid over-criminalisation.
Yeah.
And this is why we've got an exposure draft, and this is the balance you have to get right, and you want to make sure that there may be some circumstances where two episodes of something ought not to be regarded as a course of conduct.
Just getting on.
So the problem with having a numerical criterion is that you may capture in your offence episodes that aren't frequent enough or serious enough to be appropriately criminalised.
Okay.
But that's for the jury or the judge to determine.
That's right, and that's why there is no numerical criterion in there. Whereas if you put a numerical criterion in there, you are telling the jury or the magistrate that whatever you think is a matter of common sense, two episodes were enough.
It's saying here, it's saying here at least two occasions. So it's not just saying two occasions. There could be a sequence of those occasions afterwards, but at least two occasions would constitute a breach.
Well, look, what we've done in this case, what we've done is cherry-picked from different legislation overseas. In this case, we've taken the English and Welsh approach rather than having an arbitrary number. But again, it's an exposure draft, and I'm not. That's why it's an exposure draft to flush out these sorts of critiques and have an informed evaluation.
But just on that issue of the exposure draft, some stakeholder groups, such as DV New South Wales, has said that the 6-week time frame wasn't sufficient, and given the nature of the legislation, its novel qualities, that longer would be better. I know you want to act sooner. unlike on some of the other issues that we've been discussing, but you want to get this done, I appreciate that, but we also want to get it right. Wouldn't a longer consultation period enable better engagement to bring out some of these tricky questions to make sure that the legislation enacted?
Yeah, we have to balance, as I said before, the risk to lives the longer we wait, because of coercive control being a red flag for domestic violence homicide, but on the other hand, having adequate time. This is not the start of a consultation process. This is a process that started at least as long ago as October 2020 with a fairly detailed discussion draft, with a joint select committee that ran for 9 months, where there was 11 weeks for written submissions, there were 6 days of hearing.
But the devil's always in the final detail, isn't it? The actual.
That's right, and we're now at the pointy end. But this is not something that where we're having a standing start. This is consultation that has been going on since October 2020, and while it's novel in the sense that police and others have generally got incident-based approaches to criminal law rather than a course of conduct. It's not novel, though, in the sense that we won't be the first jurisdiction in the world doing this. We can learn from the experience in Scotland and England and Wales and Northern Ireland and Tasmania, for that matter. So it is not novel. The approach we have taken in our exposure draft is to prefer the English and Welsh drafting in this area rather than the Scottish drafting, but that's what it's there for as an exposure draft. And we are confident that 6 weeks should be adequate time for people to comment on that, particularly as it's not just 6 weeks unaided. We are facilitating round tables, at least 10 round tables with relevant groups to flush out and discuss these sorts of issues. So it's not just written submissions, ships crossing each other in the dark, that there's a kind of Socratic interchange to discuss these issues, to flush out strengths and weaknesses.
Right. Can I draw attention to the time, if that's okay? We're just going to break for morning tea. We'll reconvene at 11:15, and the opposition will have a few more 16 minutes when we resume.
Thank you.
Thank you, everybody. To reconvene?
Thank you. Yes, please.
Well, let's do that. Thank you. So we'll pick up where we left off, and that is with 16 further minutes over with the opposition. Thank you.
Thank you, Chair. Mr Attorney, the subject matter of the Special Commission of Inquiry into ICE, you'd accept that that's a pretty important inquiry? And it went for 14 months, but it's now been 30 months since that report was delivered. When I understand that when Dr. Howard delivered his report, he tried to see the Premier but wasn't able to, and he had to sort of deposit the report at the reception at 52 Martin Place. He wasn't able to see the Premier on that occasion, and I believe he's reached out to the Premier, the former Premier at least, on a number of occasions, but wasn't able to secure a meeting. Have you met with Dr. Howard in relation to the ICE inquiry recommendations?
No, I did meet Dr. Howard before he provided his report. I have not met him since then. I may have written to him.
Happy for you to take that on notice.
Take it on notice.
Yeah. But you'd accept that the people who came forward to give evidence to that inquiry about their lived and quite horrific experiences, that there'd be a reasonable expectation on them that the government would respond in a timely way to these important issues? You'd accept that?
Yes.
And leaving aside the disrespect to Dr. Howard from no one in the government talking to him, there's a disrespect to all those who participated in the inquiry to not have heard from the government to date. Would you accept that?
Look, I'm disappointed that we haven't yet had a formal response to the ICE inquiry. It is a very important inquiry that is founded on extensive research, evidence, and a very extensive report. So it is disappointing that there has not yet been a formal response. I'd note that most of the report doesn't concern my portfolio. It's mostly, and drugs are basically more a health issue than a legal issue.
Or should be.
Or should be, yeah. But to the extent that there are legal issues that were the subject of recommendations, where it has been possible to hide those off and deal with them ahead of a formal response, I've tried to do so. So, for example, expanding the youth Koori court was a recommendation. I've announced that's expanding to Dubbo. Expanding circle sentencing was a recommendation. We're expanding that to another 8 sites. Expanding justice reinvestment was a recommendation. We're doing that. Expanding the drug court was a recommendation. We're doing that. The Wallama, there was a recommendation for a Wallama court. There's a list that started earlier this year. So,
and a longitudinal study by Boxer.
I beg your pardon?
And a longitudinal study by Boxer.
That's correct. So it is not as if nothing has happened, but I accept that there is a very lengthy delay in the overall response, and that's a matter of disappointment to me.
Yeah. Well, I think in November you said you'd be disappointed if it was not this year, that is 2021. And of course, in March you were similarly disappointed. Imagine the disappointment must be giving way to despair at this point.
No, I remain disappointed.
All right. The Premier, not that long ago, said that the government was very close to finalising a response. Can you shed any light on where that's up to?
That's my belief, but ultimately, ultimately, it's in the hands of the Premier and Cabinet generally.
Okay, well, how did you receive the report from Dr. Howard? I mean, were you just given a copy by the Premier's office?
I'd have to refresh my I think that's the case. I don't think he wrote to me directly.
Okay.
Because it was the Premier who commissioned the report, so I think the report went to the Premier. It might have gone to the Governor.
Okay. But you were furnished with a copy of the report, but you didn't, reading the report or getting briefed on what it had to say didn't prompt you to want to meet with Dr. Howard to better understand his thinking or the sense of urgency that seems to underpin it?
It is a fairly clear report. It's extensively footnoted. I've certainly looked at sections of the report that involve the law very closely, and not just the report, but primary materials that are footnoted there as well. So the report, on one view, speaks for itself.
So you don't need to be persuaded or convinced about the logic behind its proposals.
Well, that logic is a matter for Cabinet. There are over 100 recommendations, a handful of which were ruled out fairly quickly by the then Premier. I have put on the record pretty clearly my view about the general direction of pre-court diversion without disclosing what has been to Cabinet or what may be before Cabinet. So my view about the general desirability of a diversionary approach is pretty clearly on the record.
Right, well, given that Dr Howard hasn't been able to meet with at least the former Premier, I don't know whether he's tried to meet with the current Premier, hasn't been able to meet with the Health Minister, you haven't sought to meet with him because I intuit you seem to be convinced about what he has to say. How come no one in the government wants to speak to him about the report?
Well, look, you'd have to ask individual ministers that.
Okay.
I can't answer for what they choose or
I'm only
choose
asking
not to
you
do.
in a representative capacity, you understand, Mr Attorney?
And I've provided my answer.
Okay. How many of the recommendations do fall within your portfolio?
Can I take the precise number on notice? But
Sure.
But certainly a minority.
And what have you done to progress those? I understand they're within a wider framework, but those that do fall to you, what have you done about them in the 30 months?
Right. So certainly had extensive briefings from the agency, taken submissions to Cabinet, spoken with colleagues to discuss the merits or otherwise of matters that fall within my jurisdiction, taken the matter to Expenditure Review Committee for funding for certain proposals, made the announcements that I described before in relation to some legal matters, Koori Court, Drug Court, circle sentencing, justice reinvestment, while on the list.
So to the extent you can, you've progressed the bits that fall to you.
I have probably spent hundreds of hours trying to progress it.
Is it the police minister who's been standing in the way of?
Oh, look, I can't get into the details of discussions with colleagues, and I'm not. By the comments that I've put on the record, I'm not purporting to disclose what might be before Cabinet or has been before Cabinet, but these are matters which some people will have views on, and that's what Cabinet's there for, to thrash this out.
Well, perhaps I could ask a different question, which is it the police force that is resisting a number of these proposals? Historically, and I can speak from my own experience, they have historically been antagonistic towards these kinds of policy changes. Is that where the resistance within the government framework is?
I can't reveal confidential communications within Cabinet, but I'll note this in response to that. The then police commissioner made a submission to the inquiry where, in his view, a pre-court diversion scheme, if accompanied by appropriate health interventions, could have a profound positive impact on drug addiction in New South Wales. So that police commissioner is on the record supporting pre-court diversion. That commissioner was part of an inquiry that looked at overdoses at music festivals and made a recommendation for an infringement notice scheme at music festivals. The previous police commissioner before him, Andrew Scipione, is on the record of supporting a pre-court diversion scheme. What the police minister or other ministers may say in Cabinet, I can't disclose, but the police have been pretty open in their support for a pre-court diversion scheme. And of course, just to be clear, although that is the issue that has attracted the most interest in the media and in political discussion, it's only one of over 100 recommendations.
Yeah.
And certainly the bulk of the recommendations and the bulk of the response are about health interventions rather than legal responses.
Sure.
Or about other diversionary schemes, for example, expanding merit.
Certainly, but we've got a situation where, this inquiry was called, I think, before the last, perhaps during the last state election. It seemed to diffuse a difficult situation for the government where there was division or apparent division within the government about drug law policy and responses. So it gets kicked down the road by having an inquiry. 30 months after the inquiry recommendations are delivered, there's no tangible signs of action by the government as a whole, leaving aside the evidence you've given here today. Shouldn't the people who participated in the inquiry and the community of New South Wales just draw the conclusion that calling that inquiry was a bit of a stunt?
No, not at all. Not at all. You would not call an inquiry that you know is going to cost many millions of dollars unless you're interested in its outcomes. I think at the time that Premier Berejiklian called that inquiry, she recognised the insidious nature of drug addiction in New South Wales, particularly ice addiction and particularly in regional areas. So it is hardly a stunt to call an inquiry which you anticipate will make serious recommendations to which the government is going to have to respond. So certainly not a stunt. Certainly an inquiry called in good faith, funded extensively by the government, and the absence that so far of a formal response does not indicate an intention to kick it down the road. It just indicates that Cabinet has not yet made up its mind on one or more of the recommendations.
I understand, but there's no need for Cabinet to deal with everything all at once. I mean, presumably it could work through them progressively and decide what it's going to do. These are complex issues, but is it that hard that it's taken?
Yeah, I guess if you were back in 2020 and you thought that we would be where we are now in 2022, you would attempt to hive off more things. But we have been on the cusp of a formal response for a long time. And at each point along that way, it has seemed to be more productive to get the final response done than start hiving off things, which will just delay a final response. Now, with the benefit of hindsight, you might approach things differently. That is how it has been the whole way through. And bearing in mind the delay in the final response is why I have tried to hive off where I can. And I've mentioned some of the things that I've hived off and announced.
All right. Well, I think whether it's 5 weeks or 6 weeks of sitting that is left in this Parliament, certainly this year, do you realistically, are you able to tell us that it's a realistic expectation that the government will bring forward legislation to address its response to the ICE inquiry this calendar year?
Well, that is my aim, that any legislative response that is required would be this calendar year. But it's unlikely that any primary legislation would be needed. So if, for example, we were to expand the merit scheme, that doesn't require legislation. If there are more rehab facilities or better health facilities in different areas, that doesn't require legislation. There is already a regulation in place, I think under the Criminal Procedure Act, that authorises the issuing of infringement notices for any drug, possession of any drug, anywhere in New South Wales. So that is already broad enough to cover at least one sort of pre-court diversion, if the penalty were $400, which is what's in the regulation. At the moment, though, operationally, police don't do that except at music festivals.
Well, just speaking of...
So that, if that were to be broadened, that doesn't require a legislative change. There may or may not be tweaking of regulations, but my current anticipation is to expand pre-court diversion would not require statutory or primary legislation. And I don't think any of the other responses to... Well, sorry, there's one. The Criminal Records Act, there's a recommendation about wiping the slate, I think, at 2 years rather than 10 years for expunging drug offences from criminal records. That would require a legislative fix, I think.
Yeah, I mean, look, during COVID, of course, that wasn't a real live issue about music festivals and gatherings and stuff. But obviously now that that has receded, at least from the popular consciousness, and there does seem to be a return to face-to-face gatherings. It doesn't seem that the government actually has a coherent drug policy to deal with that. The ICE inquiry, I think, was sort of meant to provide that content. From my count, it seems there's been no proactive government drug policy for nearly a decade in this space, and it's just been delayed further.
I don't
Time
agree.
to draw a line under it, isn't
Look, drug policy is not just me. It's not just me as the first law officer. It would be police, health, premier, education minister. I don't agree with that characterisation. The ICE inquiry and its recommendations are not about starting a drug policy. They're about amending the way we deal with drugs at the moment with a three-pillar approach of supply reduction, demand reduction, and harm reduction.
But I mean, now that we're returning to face-to-face gatherings, there may be more dance parties, there may be more music festivals. The need to address the contents of the ICE inquiry now becomes, more pressing than it has in the last year or two, doesn't it?
Look, I don't know that it's more pressing. It is pressing. I accept that. Music festivals, in terms of pre-court diversion, music festivals are already dealt with, except that there's no health intervention with an infringement notice at a music festival. But I think the vast majority of illicit drugs are not consumed at festivals or parties. There'd be people with daily habits, or recreationally doing them elsewhere, or consuming them in private. So I don't know that it's more pressing, but I accept that it's pressing.
Well, we'll come back to that.
Okay.
Thank you. Ms. Abigail Boyd.
Thank you, Chair. And good morning.
Good morning.
And to all of your officials here as well.
Thank you.
Now, I know that my colleague, Mr. Mosselman, has already asked you some questions about the coercive control legislation. I just wanted to pick up on a couple of those points. Just firstly, I know that you're aware that there's, the sector has been asking for a little bit more consultation time. Is there, just on that basis, is there any sense that now that we have a change in federal government, that there is going to be some movement towards a national definition of domestic violence and abuse, that it might be worthwhile waiting for before this legislation goes through?
So there are national principles that are being developed, and there's a consultation draft that Attorneys General agreed to release on the 12th of August. I'm satisfied that our exposure draft it falls within those principles.
Mm-hmm.
So those principles, it's pretty clear in those principles that the aim is not to have substantially identical legislation and statutory definitions across the country, and that's not just my gloss or interpretation. I think there are explicit statements in the consultation draft to that effect. Broadly, though, in fact, there's not even in those principles agreement that each jurisdiction will criminalise coercive control. It's rather, here is an overarching framework of analysis to guide you if you choose to criminalise coercive control. Have regard, for example, to the possible effect on First Nations people. But there is no that is a consideration to be taken into account, but there's no prescription about how you take that into account or what the drafting solution is to that. And I don't think there will be any drafting prescription in these national principles. So they're out for consultation. They're pretty broad.
Mm-hmm.
They all seem. So consultation. Sorry, I'll withdraw that. The consultation starts in September.
Right. Okay.
Consultation starts in September. Are they out?
No, they're not out.
Sorry, I'll have to correct
I was
myself.
going to say, I don't believe
No,
that.
they're not out. They're not out.
Yep.
But they've been agreed upon. They will be out in September, and it is, having taken advice and my own analysis, it's clear to me that our exposure draft is consistent with, doesn't depart from those national principles. So I don't think that is a reason to hold up drafting in New South Wales.
But I guess, this is something that's being put out for consultation, though, in September. So presumably the consultation is for the purpose of hearing back from experts and frontline workers. So you could well end up, and I would hope that that consultation actually improved the drafting. That's what we want consultation to do. So you can't really be confident, can you, that the drafting of the exposure bill is going to be consistent with what ends up being agreed as part of that national process?
Oh, look, they're pretty broad principles. I don't think there's anything in there that is problematic or controversial, so I would be confident. But look, a point, and this is not, it will not to point score, but to put this in context, to criticisms that there isn't enough consultation on this. This is the fourth round of consultation. There was the from October 2020 when we announced the Joint Select Committee to now, there was a discussion paper. There was an 11-week period for written submissions. I get the comment that part of that was over the Christmas New Year period, but it's still 11 weeks. It's a pretty large chunk of time to make written submissions. 6 days of hearing, 70 witnesses. So 2 rounds of consultation there. Before this exposure draft came out, we consulted legal stakeholders to deal with the sorts of issues that Mr. Mosselmain talked about whether you have a numerical prescription or not, and the Aboriginal Legal Service, and now this round. Before we put out the discussion paper in October 2020, I'd been speaking for some months with stakeholders, with wearing my then dual hat of Domestic Violence Minister and Attorney General, speaking with people in Scotland and England and Wales and so on. So this has gone through a very extensive process. Anna Watson put up a private members bill I think late 2020 that was voted on in early 21, a very much more wide-ranging bill than this one. There didn't appear to be any formal consultation on that, and yet Labor MPs and Green MPs in the lower house were prepared to vote for that bill absent any consultation other than there might have been informal stakeholder
I'm not sure
feedback.
about the Greens MPs.
Not sure.
So I'm not.
Yeah,
I'm not.
I don't believe that
I'm not
it actually
making.
went to a vote.
I'm trying not to, and I'm not doing this to.
Could I stop you there, though? Because
You're not trying to
I'll
bait us, Mr. Attorney, are you?
I do think you've forgotten about
can I just
the
finish the
excellent
sentence?
bill that
Yeah,
the
if
Greens
the
drafted
attorney could answer
that
the
went for an 18-month consultation. We had about 4 or 5 exposure drafts that were sent out to the sector, to experts, to a whole bunch of people. The bill that I presented in the upper house had 18 months of consultation and was put forward on behalf of the sector.
But ultimately,
differs in material respects from the one that you have put
well,
forward.
I'm certainly would invite your feedback on this exposure draft and welcome that. But in the end, and I'm saying this is not to point score, but to put in context our lengthy consultation, Labor and the Greens in the lower house were prepared to vote for a bill.
I think you're mistaken on that. It didn't go to a vote.
It did in the lower house. It didn't go to your house. It did in the lower house. No, not your bill. Not your bill. Labor's bill.
No, I know, but it also... Sorry, we didn't vote on that. The Greens didn't vote on that.
You did. I think you did.
Okay.
I think you did. And I'm not having a...
Have a look.
But I'm doing that just to draw a comparison with...
Because there were significant flaws in that bill.
The approach of voting members of the Legislative Assembly to that bill and comparing that with the enormous amount of consultation and rounds of consultation we're doing now.
So coming back to your consultation, so during the Joint Select Committee, of course I was a member of, it was very clear that was an inquiry about whether or not to criminalise coercive control, rather than it being an inquiry into a particular draft. And you and I know that there are many different elements, different ways that you could draft the elements of this offence, which is why the Greens bill was so different to Anna Watson's bill, but also why the Scottish bill is so different. Scottish law is so different to the English law, etc. But during that inquiry, if we do look at that inquiry as a form of consultation for the drafting, there are a number of elements you've put in your exposure draft which were not majority supported by the people who had put in submissions. So I'm not sure that you can claim that was consultation that supports the bill that we have before us. The bill is very specific. 6 weeks is not a long enough period of time to properly consult.
Well, I would respectfully disagree because we're not doing this from a standing start. We're doing it, as I say, from October 2020. And I get your point that was about whether or not, rather than the precise wording. But this is not at a standing start. We've done that overall consultation and getting stakeholder submissions on coercive control generally. We're not doing this from a standing start as the first jurisdiction in the world to do it. We are informed by what has happened in Scotland and England and Wales, and it's not 6 weeks. Do what you like. Here it is. Put in your submissions, and we'll open the box in 6 weeks and see who said what. We've got targeted roundtable consultation.
I'm glad you raised
to facilitate discussion.
So I'm glad you raised, that we can look at Scotland. We do have those jurisdictions who have done this before us. The Scottish Act is being reviewed, and there will be reported back in September what the, looking at the data and how it has been implemented and whether it's been effective and what they could do better. Wouldn't we be better off then waiting to see that review before we push ahead with this legislation?
Well, I think there'll be time to look at that.
Before we pass the legislation?
Yeah, well, the legislation, it won't be, I don't anticipate the legislation will come to Parliament in September.
Okay. Can I ask you, the recommendation 21 of the Joint Select Committee was that the exposure draft would actually go through a consultation process guided by the implementation task force. And that was supported in the government response. So just to be clear, the recommendation is that the New South Wales Government releases an exposure draft of legislation for a coercive control offence as a priority, with proposal of final legislation following further consultation through the implementation task force. The committee was very clear that we did not want to see a draft of this bill put forward before the implementation task force that then comprised First Nations representatives from called communities, from people with disability, had been established first. Why have you departed from the response to that recommendation?
Well, I'd say I would read recommendation 21 in light of, in conjunction with recommendation 20. Certainly will, I think, give consideration to an implementation task force after the legislation has passed to deal with the sorts of training, community awareness, education that I was adverting to prior to morning tea. Hang on, I haven't finished.
It's quite specific.
Sorry, I haven't finished. But we... But I think, I would say that we are fulfilling the spirit of that, because rather than just me turning up at Parliament one day, doing a notice of motion and second reading something the next day, we are releasing an exposure draft of legislation.
Sure, but then you could have just stopped it before the comma, couldn't you? But
well,
what we've said is that the final legislation would be following further consultation for the implementation task force. And if you read the report, it's very, very clear that the threat of unintended consequences from getting this drafting wrong was deemed to be so great by the committee, after all of the evidence we heard through this great consultation process that you initiated, for us to then depart from this recommendation.
Well, I think the spirit has not been departed from. We are releasing an exposure draft, and as I said, I could have just simply turned up 1 week in Parliament, given a notice of motion, and second read a bill the next day, not shown it to anybody, given my opposition colleagues would have just, and crossbenchers would have just seen it on 5 days' notice, and you would have turned up at 11:30 one morning and been given a 5-minute whirlwind tour of it at the crossbench briefing. So we are conforming with the spirit of that recommendation, and in terms of unintended consequences, well, that's the very purpose of an exposure draft and roundtables and feedback, to hear from stakeholders what they fear the unintended consequences might be. But those unintended consequences, of course, have been agitated quite significantly in the Joint Select Committee hearings, the question of
which is why the recommended drafting was quite different to what you've now produced.
So issues like, will it be turned on victim survivors? Will perpetrators say they've been coerced? What's the effect on First Nations people? They were issues that were agitated at some length before the Select Committee. So we know what those issues are. It doesn't require, in my humble submission, a different approach from what we're having now, where stakeholders who have raised these issues can say what drafting might improve. But take the issue of victim versus perpetrator. As I said earlier, I don't know that any drafting can overcome that risk. The way to overcome that risk is training of police and general community awareness.
I agree with you that the education piece is more important, but the drafting, there are elements of the drafting which are quite different. But I just wanted to correct the record in relation to the Greens voting on Anna Watson's bill. I understand our position was that we would see it through to the second read, but that we would then be proposing significant amendments to it. So just so we're very clear. Can I move us on slightly?
But not referring it off to a lengthy consultation process.
Well, we had already done our lengthy consultation process. We know what the bill should look like. And if you read the submissions, you'll actually see one of the academics refer to the Greens bill as the gold standard, but your bill is quite different. In any event, let's move on. Can I... Yes, we have the bronze standard from you, Attorney General. It's very sad. Can I ask you something?
Well, if you say it's the bronze standard, it's very important that you and those you speak with provide us with the feedback.
And I will.
I mean, I don't accept it's the bronze standard, but if you say that, I want to know why we're not gold medal winners. And
yes,
yeah,
I will provide a detailed submission by the closing date.
We want to hold the world record.
Good. I'm glad. Can I ask you about something totally different? I want to ask you about deaf jurors. I understand that the New South Wales Law Reform...
For jurors.
Deaf jurors. I understand that the New South Wales Law Reform Commission wrote to the government asking them to amend the Jury Act to allow deaf people to serve on juries. Why has that recommendation not yet been implemented?
I'll have to take that on notice.
Thank you. Do you agree that it's important that we do allow for deaf and hard of hearing people to be jurors?
Where possible, but I'll have to take on notice
Thank you.
That whole area.
Are you aware that Article 29 of the United Nations Convention on the Rights of Persons with Disabilities effectively seeks to guarantee that deaf and hard of hearing people can serve on juries, and also that the UN Committee on the Rights of Persons with Disabilities found that the exclusion of deaf people from jury duty was a failure of the New South Wales government and a breach of Australia's obligations under the convention. They actually had that in a finding.
I'll take all that on notice if I may.
Thank you. I will ask you, sorry, how much time do I have? 3 minutes. If I could then ask you very quickly about drink spiking. Now, do tell me if this is not really a question for you, but I understand that there's been a marked increase in drink spiking at licensed venues since we came out of lockdown, and also that there's been a concerning, really horrifying number of incidents where young women have been spiked with a needle in certain clubs and pubs, particularly around Newcastle. Are you aware of this, and do you know if the government's taking any action to address it?
It's probably a matter for the police minister.
Mm-hmm.
If you want me to list the various crimes that would be committed, I can take that on notice. There'd be assault among others. But in terms of an increase in crime reporting, and that is operationally, I think, a matter for the police minister.
Yeah. Is it an issue, though, that's been brought to your attention at all?
Not that I can recall, no.
Okay, thank you. I'm just wondering where to go next. I might just leave it there because the next segment I have is quite large, but yeah, thank you.
Okay, over to the opposition.
Mr. Attorney, I think when we left off, we were going to gently touch on the issue of strip searches. We were talking about music festivals and government responses.
Okay, you hadn't mentioned strip
Okay, well,
searches.
I'm now mentioning them.
I'm not sure you were going to be gentle, but anyway.
I'm always gentle, Mr. Attorney. Now, the Special Commission of Inquiry into ICE also made some mention about the way in which strip searches had been conducted in New South Wales, and the Law Enforcement Conduct Commission had also found that police were failing to comply with the legal threshold for conducting strip searches, or weren't fully aware of what their powers were and weren't discharging those lawful powers, according to law. And I think even recently, in the last couple of days, there's been a further report of some 4,400 strip searches being conducted in New South Wales by police on children as young as 13 at the height of COVID, again, not according to law. Now, when we discussed this matter in March, there had been a lot of work done by the police in this space, and of course, as attorney, you have joint responsibility for the Law Enforcement Powers and Responsibilities Act with the Police Minister. And I had asked you then, given all the work that had been done, given that everyone seemed to agree on the nature of the problem and the need to clarify the law, why was it taking so long to address that? And you said that you couldn't give us a time frame for action, but you hope to have the matter resolved this year. It's a familiar refrain. So can I ask you, or provide you with the opportunity to update this inquiry now about what is the time frame for action on clarifying the law around strip search powers of police?
Sure. So as you...
Just our people in blue.
Sure. So as you correctly identify, I have, unlike with the Child Protection Register, I do have responsibility for LEPRA, joint responsibility with the Police Minister.
Mm-hmm.
My recollection is I think there were 3 recommendations that LEC made that were directed to possible legislative reform.
Mm-hmm.
The vast majority of the LEC recommendations were directed to operational matters for the police, which I understand the police contend they have largely addressed. The position with legislative reform remains where it is in March. I can't give you any time frame.
Do you expect it to be this year? Are you optimistic, like you are with the ICE inquiry recommendations and like you are with other matters that we've discussed today? Or are you less optimistic?
I can't say any more than I've said.
Oh, well, we'll take that as not optimistic then. Bail laws. We discussed bail laws at the last budget estimates, and I think in the wake of that there were some changes to bail laws, particularly around the monitoring standards for electronic bracelets. And I think we were all just surprised to discover that these were being conducted by a private company. I think there's one private company that provides them in New South Wales.
Electronic monitoring for parole is done by corrections.
Yep.
Electronic monitoring of people on bail is not something that the state asks for or offers, and it's not something that prosecutors offer. And I think, as I said last time, they generally oppose electronic monitoring. So this is usually something that an accused proffers as a risk mitigator, and why they should get bail. And the effect of that legislative change and regulation is to prescribe minimum standards, which mean that electronic monitoring of an accused on bail will broadly have the same standards as electronic monitoring by corrections of someone on parole.
So you've made a regulation, I think, to implement that. What's interesting is that there's a whole lot of musts. You must do this, must do that. They must have these features. But when it comes to stationary beacons or home units, the regulation says must be reasonably robust and tamper resistant. So the robust and tamper-resistant seems to be qualified by reasonableness, whereas all the other features are mandatory. Can you explain why that is?
I'll have a go, and then I'll invite Mr. McKnight or someone
Please.
else to either correct or supplement.
Yep.
So my understanding is that these regulations were drafted having taken the advice of corrections about what were appropriate technical specifications. No electronic monitoring is completely foolproof. It's not. You cannot 100% guarantee that an accused or an offender won't be able to take off the electronic bracelet. So that's why I think there's a question there of reasonable robustness rather than absolute robustness. Is that correct?
Yes.
Yeah, so Mr. McKnight nods his head.
Well, interestingly, because other features, even in that clause, must utilise the latest radio frequency, must be able to communicate, must be able to automatically tether to the person. These are all pretty clear requirements, and they would seem to be falling into the same sort of category as being tamper-resistant, but they're not qualified.
I'm certainly not an expert in this field, but take the latest radio technology.
But I can.
That you could presumably identify what is the latest radio technology. What was your next one?
Must be able to automatically tether to the person. Like if it's defective or it doesn't do that, it's obviously in breach of the regulation.
Well, that sounds like something that can be done in absolute terms rather than relative terms like relatively robust.
Okay, well,
reasonably robust.
We'll just come back to that. In your answers to question on notice, you indicated that there was currently only one company known to be providing these services in Australia, the Attenti Group. Do they also deal with the ankle bracelets that are supervised by probation and parole? Are they the same?
You mean do they monitor them or
Do they
manufacture
them? Is it the same manufacturer? Are we talking about the same devices?
I don't know the answer.
Okay, if you can take that on notice.
I believe not.
Okay.
I believe they're a separate company.
Okay. So when this regulation was it drafted to meet the requirements that the Attenti Group already meet, or was it sort of drafted to try and raise the standards? And has there been any sort of analysis about what the Attenti Group devices actually do or are capable of doing to see whether
my understanding was it was to impose on electronic monitoring for bail broadly the same standards as currently apply for parole. So it wasn't to write into regulations what was already being done for bail. It was to write into regulations
the standard you want.
The standard we want, which was the standard that applied for parole.
Okay. And could I just ask, who is the supplier of the devices then for probation and parole? And
I can't name the supplier. What I can indicate is that the corrective services devices are different to the bail devices.
But they do the same thing, don't they? Actually, the chair just needs to make an announcement.
I apologise. I just have to slip out, and I'm just handing over now to Mr. Searle to take the chair. Thank you, everyone.
Thank you.
Thank you. Don't they do the same thing? I mean, they're meant to monitor a person to make sure they do or don't do things required by law. Shouldn't they be the same devices?
My
response
was to indicate
I could answer that. I could answer that at an abstract level. I mean, you can have, a rat test has the same function of detecting coronavirus, but there are differences. So it's the same functional specification, but the way they do that might be different, and maybe that's the case for electronic monitoring. It's the same outcome and function, but the technical specifications could be different.
Okay. Now, Mr. Attorney, you tasked the Bail Monitoring Group at the end of 2021 with reviewing and making recommendations on 7 contentious decisions. Have they reported to you?
Yes, they have.
Will that report be made public?
So I've made public the recommendations and the executive summary. I haven't made public the rest of the report, over which I would assert Cabinet in confidence. There are a number of reasons for that. One is it may I'll go back one step. The Bail Act Monitoring Group includes representatives of the police, the DPP, and in some cases, disclosure of some of the contents may prejudice either existing operations or ongoing operations. In other cases, there was material there that members of the group provided in confidence, opinions in confidence, that they don't want to be identified individually. So I've tried to balance that with transparency by releasing what the recommendations are and the executive summary.
Earlier today, I think you indicated that there might be some further legislative action on bail being proposed by you. Can you outline what actions you intend to take?
So there were... bail is always a balance between the liberty of the accused and the presumption of innocence on the one hand, which is not some arcane legal airy-fairy idea, because accused do get acquitted, and if they are held on remand, there's generally no compensation for that if they end up being acquitted. So you're balancing that on the one hand with risks of offending if they're on bail, risks to witnesses, flight risks, and so on. So it's always a balancing exercise. We have in the Bail Act show cause offences where for certain very serious offences that are listed in the Bail Act, the accused has to show cause why they should get bail. They include some firearms offences. They also include some offences where there are associations with criminals. The Bail Act Monitoring Group identified that area for further consideration, but did not provide me with a recommendation to do something or not to do something. They didn't give me a clean bill of health for the list being long enough, but nor did they recommend that I add to the list. Similarly, they recommended that I refer these matters to the Sentencing Council. They also recommended that the department look at definitions of criminal associations and whether that can be clarified. I thought it would be more expeditious to deal with all three recommendations by one body rather than split them between the department and someone else. I thought it would be better to refer it to the Law Reform Commission rather than the Sentencing Council, because I don't want this to be endlessly kicked down the road. I want it brought to finality. And referring it to the Law Reform Commission is the most expeditious way of doing that, because the Sentencing Council has an ongoing reference on fraud. So the Law Reform Commission had more capacity. And having spoken with the chair of the Law Reform Commission, I'm confident that I can get a report in time on these fairly discrete issues. It's not like some of the other more wide-ranging Law Reform Commission stuff that can take years, in time, so that if we decide to expand the list, that can be done in this session. I couldn't just leave it and do nothing when it hasn't been given a clean bill of health by the group, but nor, in my view, was it appropriate just to add to the list at my whim when I don't have either expert advice or a consensus to do that. So that's why it's gone to the Law Reform Commission. Fairly discrete issues, which I'm confident can be resolved one way or the other this year.
Right. So have you made that reference to
I have.
Have you given them a limited time frame?
Not in the terms of reference, but I've spoken with the chair.
And are you able?
And before I made the reference, was confident that I would get a timely response.
How timely? Are we talking 3 months? 2 months?
Oh, well, in time. Ideally in time to introduce in October in the Legislative Assembly, but certainly in time to legislate in both houses in November.
Okay. And it's your expectation, is it, that it would deal with show cause offences, firearms and sureties? Those three things?
Firearms and criminal associations.
Okay. But not sureties and not show cause offences?
No, there were no recommendations. Well, sorry. Show cause offences which involve criminal associations.
Yep.
And show cause offences which involve firearms.
Okay. But that's the only areas that you're anticipating legislative action being taken?
At the moment, that's correct.
Okay. All right. Thank you. I think this issue may have been raised earlier today by one of the other committee members, and if so, I do apologise. But the latest bail reforms have reduced early guilty pleas, and I think that's one of the consequences of that legislation that went through. And there are reports from the local court in particular that the courts are becoming increasingly strained as a result. Is that something you'd received advice on as a potential outcome before the legislation was drafted?
So there's a premise in your question that I don't accept. You said that it is reducing early appropriate guilty pleas. That hasn't been established. There is a fear that has been expressed that it will, and I've articulated in answers to Ms Higginson why I don't anticipate that to be the case, but we will keep it under review.
Okay. So you're not getting reports that it's actually happening?
I've had, there were suggestions that it would happen. I've not had reports that it has happened or is happening.
Okay, can I ask you to make inquiries from the heads of jurisdiction about whether that's happening?
Well, Mr McKnight has said he has described what our monitoring program will be. And what was the second part of your question?
Had you received advice that that was a possible outcome when you were developing the legislation?
Well, we'd received submissions that was a possible outcome, correct.
In particular from the Bar Association? Yep.
Correct.
All right. In the few minutes I've got left of this round, I just wanted to ask you some questions about Community Legal Centre's funding program from 2023 to 24-25. I believe you wrote to the Community Legal Centres in October, or at the end of October 2021, indicating or confirming that the $21.6 million of baseline funding allocated through the Community Legal Centres funding program would continue for the next 3 years, plus indexation each year. I'm informed that community legal centres are not receiving the promised indexation on their baseline funding. Is that correct or not correct? And if it is correct, what has happened since the 28th of October when you wrote to them?
Sure. I'd have to check that letter to see exactly what I said.
I can provide you with a copy if you can't lay your hands on one.
Okay, thank you.
It's in the second paragraph, Mr. Attorney.
Thanks very much. Thank you. So what was that? Was that defined?
No, it's Monique's issue.
Excuse me a moment. I might ask Ms Hitter to answer that question, and then I've got some supplementary remarks.
Of course.
Thank you.
My understanding is that indexation to payments to the CLC program are at different rates depending on the source of funding that the CLC program contains. So, for example, there is 1.7% indexation on the Commonwealth funding, 2.5% on state funding, and 2.5% on public purpose funding, public purpose fund funding.
And Mr. Attorney, is it the case that you're saying that to the extent that the money comes from the state government or from the public purpose fund, the 2.5% indexation has been delivered? Because
that's my understanding.
That's my understanding. That's Ms Hitter's understanding, but we'll check that. I might just make these supplementary observations. Community Legal Centres New South Wales has been in contact with my office in the last couple of weeks, drawing our attention to the current inflation rate.
Yes.
And the impact that will have on their operations. And we're looking at that at the moment and what an appropriate response would be to that.
Okay. All right. So indexation is at the rate of the wages cap rather than at the rate of inflation?
Well, it's below the subject to checking where in what document we have defined indexation, if at all. It appears to be at 2.5%, but I'm conscious that community legal centres say that their operating costs are accelerating at greater than that rate, and I anticipate dealing with that issue very shortly.
All right. Well, I think I've got...
So in terms of your scale of optimism, I'm
More optimistic, less optimistic?
highly optimistic, because I don't have to rely on cabinet colleagues for their imprimatur. I can make decisions myself
Okay, well, this is very reassuring.
to some extent.
Okay, well, I think this round will end in 14 seconds, so
Right.
I might just pass now to Ms. Boyd and reset the clock.
Thank you.
Thank you. It's all very civilised, isn't it? Thank you. I wanted to ask you about the Folbig matter with Ms. Folbig. I understand that a pardon petition had been submitted to you, and that pardon was denied in favour of instead going ahead with with an inquiry. Can I ask you why that pardon was denied?
Sure. So look, I need to be a bit circumspect, because I don't want to do or say anything that prejudices the conduct of the inquiry that is underway. I think I made comments on the record about this. In my view, I mean, this is an extraordinary case, and on any view, incredibly tragic. The loss of 4 lives. There was, given the overwhelming, I'll withdraw that, given the widespread support for doing something in the scientific community, there was certainly the threshold for action by me had been passed. But I formed the view that it was not appropriate where Ms. Folbig had been convicted in an open trial. There had been numerous attempts to set aside or deal with that judicially, that I or the Governor, on my advice, should do something behind closed doors without a transparent inquiry. That includes, for example, having some kind of round table with the scientists that supported her position. If there is to be a conviction through a judicial or quasi-judicial process in a transparent way, then dealing with that or pardoning that should also be done transparently, which is why I chose that path.
Okay. Did you receive legal advice about that, to back that up?
I did. So I received legal advice from Mr. Game, SC, Joanna Davidson, and one other barrister.
Thank you. I suspect...
And I think General Counsel in Department of Communities and Justice also provided advice.
Thank you. I suspect I know the answer to this, but would you be prepared to share that advice with Parliament?
No. That advice remains privileged, and I don't intend to share that advice.
Given everything you've just said about not providing the pardon, but given the widespread support for and the fact of new evidence, etc., it's important that we fund Ms. Folbig's representation fully, or in a fulsome manner, to allow her to actually participate in this inquiry. It is when you announced the inquiry, you talked about it being transparent, public, and fair. And yet, I understand that the amount of funding that has been provided to Ms. Folbig's representation is severely lacking and is not allowing them to represent her fully.
She's got legal aid.
What is the reasoning for that?
I'll observe that the inquirer, Mr. Bathurst, described her legal assistance as not ungenerous. So I don't know that I agree with your characterisation of whatever assistance she's got as severely lacking. There are legal restrictions on Legal Aid New South Wales disclosing whether someone has applied or has got legal aid, but those restrictions appear to be somewhat academic because it's all been out in the open at one of the directions hearings for the inquiry. But I might ask Ms. Hitter to describe the legal representation that Ms. Folbig is getting, which I understand is the same as she had at the last inquiry in terms of numbers and seniority of representatives.
Thank you. And if you could also comment on number of days of representation as well.
I would have to take the number of days on notice, I'm afraid.
Because I understand that the preparation period was set at 35 days and not the requested 72 days. And so my understanding is that there's a lot of work being done now, completely pro bono.
If I may take that question on notice, the Legal Aid Commission Act does prevent me from providing information about grants of legal aid and the terms of the grants of legal aid. And so if I can provide that information, please, as a response to a question or notice, I can just circumscribe the information that is allowed to be in the public arena and the information that's not.
Thank you. If you could at the same time come back to me on, I understand that one of her counsel is not being paid at full rates, but is instead being paid at half the set rates. If you could come back to us on why that would be as well.
Absolutely.
Attorney, would you be concerned if Ms. Folbeck was not able to afford proper representation during this inquiry?
Well, it's in the interest of justice that she have proper representation, but nothing has come to my attention that suggests that she doesn't.
Well, I sent you a letter.
I think I replied to your letter.
You did reply to the letter. So, one more thing on the Folbeck case. I understand that Mr. Folbeck has not provided his DNA as yet. Are you aware of any reason for why that has not been supplied, and are you concerned?
No, I'm not, but that really is a matter for the inquirer and those appearing before the inquiry to make, if that is the case, to make such submissions as they choose to make, and the inquirer to make such findings as he chooses to make because of that.
Thank you. If I could now turn to the Reinvest trial, for which we have had many a discussion in the past. So this is the trial that received, I think it was $7.1 million in the end in funding.
Sadly, I'm no longer the minister with responsibility for that. You'll need to ask Ms. Ward.
Were you the minister responsible when the Reinvest trial finished?
I don't think so.
Lucky you.
That was 30 June this year, wasn't it?
Yes, it would have been.
Yeah, no, it wasn't.
Well, that is a great shame. Fine, I will turn to something else. Just bear with me. Do you want to go to you for
Yeah,
a
I'm
little
happy
bit
to
and
ask
then
some
come back to
questions.
me in a bit?
Thank you.
Mr. Attorney, why has the government increased funding for some social services to increase the Fair Work Commission minimum wage rate increases of 4.6% and super guarantee increases from 10 to 10.5%, but not for community legal centres? Are you aware of that?
I'm not aware of the former. I think well, I withdraw that. I might have. It's not in my present memory. The former.
Perhaps you should take it on notice and come back.
Sort of aware of the latter,
Yep.
and that's something we're taking into account in responding to communications we had in the last couple of weeks from CLC New South Wales.
Okay. Why has there been a delay in decisions to allocate $4 million a year in family law / family violence funding to CLCs, and when can we expect a decision to be made on that?
Ms. Hitter might I answer that question?
Of course.
I'm sorry, Mr. Searle, could you repeat the question?
Why has there been a delay in allocation of the $4 million for family law / family violence funding to CLCs?
I believe that the application process is still in train.
Okay, so you're still waiting for applications from CLCs. Is that what you're saying?
I think we are waiting for the process to determine those applications to be completed,
Okay.
to the best of my knowledge.
Okay. If that turns out not to be correct, feel free to answer further on notice.
I will, thank you.
Okay. Now, Justice Connect, I understand, is a not-for-profit service and a CLC that's funded through DCJ. I also understand that it's being defunded. Can you shed any light on why that would be, if correct?
I have no knowledge of that.
Okay.
I'll have to take that on notice.
Take that on notice, that's okay. Modern slavery. There's a modern slavery commissioner.
There is.
The Act is up and running.
It is.
But there's still a difference between the New South Wales legislation and the Commonwealth legislation about the threshold. 50 million versus 100 million, I think, is the sort of the policy debate. During the second reading speech, then Minister Harwin said that he would be taking the matter up with the Commonwealth. Can you shed any light on whether you, as the Minister now, have had any discussions with the Commonwealth about reducing the threshold to the state government, New South Wales government's $50 million policy approach?
I may not have had a conversation. I think I've written him a letter. Yeah. So on the 8th of July, I wrote to Mr. Dreyfus and continued our advocacy for reducing the $100 million reporting entity threshold to $50 million.
Okay. And so you await the federal government's response.
There's also a federal parliamentary inquiry into their legislation. I think we either have made or intend to make a submission that the threshold be reduced from 100 to 50.
Okay. So, that's good that the state government hasn't changed its policy. Independent funding for integrity agencies. The upper house's public accountability committees delivered a number of reports advocating for an independent funding mechanism for the ICAC and other oversight bodies. And that's been supported by the Auditor General. But the Premier has indicated he has a philosophical difference of opinion with that and feels that the executive should maintain very tight control on that. Where is that dialogue up to within the government? Is essentially the government has the government absolutely ruled out an independent funding model, or is it something that you're still considering?
So we, I think, have responded to the Public Accountability Committee report and the Auditor General's recommendations. That response is on the public record. Among other things, those agencies, if they were in the Premier and Cabinet cluster, will not be part of the cluster for financial purposes, bearing in mind that a cluster is not a legal entity. It's almost like an administrative notion.
It's a function of executive
it is.
Responsibility allocation. Yep.
They will no longer be subject to efficiency dividends. They will be able to make their own submissions directly to the Expenditure Review Committee and get...
without ministerial intermediation?
That's correct.
Yep.
I think they will have contingency funding in the budget each year set aside. So there are a number of responses, but there will not be some elder or parliamentary committee that will make decisions on appropriate funding for those agencies. And I might just also say in the most recent budget, each integrity agency's bid for further funding was accepted.
I note that. Is the government open to involvement of the various parliamentary oversight committees on these various agencies to their views on the funding that should be allocated? Like I know, for example, in the PAC reports, there has been suggestions that that funding considerations be passed through the various oversight bodies. Like, for example, I'm on the oversight committee for the ICAC and the LEC and Ombo Ombudsman, and getting the input of these parliamentary committees might be useful in, if you like, further depoliticising funding decisions for these bodies. Is that something the government might be open to?
Well, look, I think we've set out what our response is, which is not to formally involve parliamentary committees, but parliamentary committees are always welcome to have inquiries, make reports, as particularly the Public Accounts Committee or the Public Accountability Committee, and make recommendations.
Okay. Yep. Ms. Boyd, are you ready to take back up your line of questioning?
Come back to me. Sorry.
I'll just, if I may, then, Attorney, I know you you answered some questions from the Honourable Sir Higgins' questions with regards to the age of criminal responsibility. As I understand it, you still don't have a decision as to the age of criminal responsibility. What exactly is holding this matter up?
New South Wales' position is that we want to see what happens at a national process. There has been, for about 3 years, some dialogue at a national level. We accept that in the end, each criminal law jurisdiction is independent of the other, but there is some merit in attempting to harmonise if we can and to exchange ideas and research and education. We've been awaiting the outcome of that process. As I mentioned earlier, that process stalled at one stage, but I believe now it has been reinvigorated at the last meeting of Attorneys General on the 12th of August. And what is important in this process is that if you are going to raise the age, and we don't have a decision on that one way or the other, you're not just abandoning or retreating from dealing with young people with behavioural or offending problems. You've got some kind of alternative pathway or intervention. That is what hasn't been developed yet in this national process, but which I believe will produce some kind of proposal for us to consider probably in the middle of next year.
Well, that was my question in terms of time, and because it's being kicked around, as you say, down the road, and not on some other subject matter. Excuse me, using this same terminology, kicked down the road for some time now, over 3 years. Is it going to be resolved in mid 2023?
Well, I don't know. I didn't say it had been. You might say it's been kicked down the road.
Yes,
I said stalled because I don't think it's been put in the too hard basket. The preparation of a paper that set out some alternative pathways for these young people stalled, didn't progress. I think there is now renewed determination among interjurisdictional attorneys general to develop that process, and I can't say what our response will be to an alternative pathway that hasn't been developed and that I haven't seen. So I can't preempt something that I haven't seen.
Since there's a renewed invigoration, if you like,
that's because a jurisdiction or jurisdictions have made it clear that they will develop something, where there was some hesitancy on the part of one jurisdiction to do that when they had...
Is that the national jurisdiction?
No, WA. As I was saying earlier,
Yep.
The way attorneys general work at a national level is that typically, rather than all 9 of us working on something at once, 1 or 2 jurisdictions take the lead. And I gave the example of defamation, where New South Wales has taken the lead, likewise with digital assets. In the case of the minimum age, Western Australia had taken the lead from about 2018 or 2019, and they had led the development of an alternative proposal, but hadn't got to the stage of identifying some alternative pathway. Like they were working towards an alternative proposal in the sense of the minimum age shall be X, but not telling us, well, if that's the case, what do you deal with young people with behavioural problems or offending problems? So that's the work that hasn't been done, that needs to be done, so that any consideration of a minimum age raising is not a retreat from responsibility, but an evidence-based approach to improving community safety.
As the attorney, where do you stand? You see raising the age to 12. Was it 14? Where's your position on this?
I don't have a position because I haven't seen this alternative pathway, and the matter has not been dealt with substantively in Cabinet.
It's been going on for 3 years. I'm sure you would have had some thoughts as to... I mean, you've indicated previously, I'll just read out what you've indicated, that the cohort of states could go with 12 with carve-outs. I think that was you seem to be indicating that that's what
no. So when it was clear that the ACT was going to 14 and the Northern Territory going to 12, without the ACT in the Northern Territory and without the Commonwealth, State Attorneys General met and agreed to develop a proposal, not to support going to 12 with carve-outs, but to develop a proposal of going to 12, to consider the timing of implementation, to consider if there should be any carve-outs, and then that proposal having been developed, consider whether or not to adopt that proposal. So it wasn't support to going to 12. It was support to work up something. There's now, I suppose, to the extent that put a gate on things of going to 12, that gate is now open, the fence has been removed, and it's more open-ended, raising the age generally, which could be to 12, could be to 14. So I've not indicated a preference or review. I've just indicated a desire to work this up so that we have an evidence-based proposal in front of us, where our paramount consideration will be community safety and looking at whether alternative pathways with alternative interventions will reduce lives of crime.
Just on a different topic, Mr. Attorney, on the last occasion, Mr. Shoebridge asked you some questions about Strikeforce Raptor and Operation Monza, and you said that you were consulting on extending other provisions of the Crimes Act to cover defence lawyers, the protection that is given against interference to judicial officers, potentially extending that to defence lawyers. Where are you up to with that consideration?
Sure. So that consultation has occurred, and I look forward to discussing that with my cabinet colleagues as soon as possible.
This year?
That would be my hope. Yes.
Okay. Ms. Boyd.
Thank you. I just wanted to talk to you about independent children's lawyers. I don't know if you are aware of the hearing that the Children and Young People's Committee held 2 Fridays ago, looking into the disconnect and problems between New South Wales child protection laws and the way that family court custody decisions have been made. And I know that this is something we've talked a little bit about in the past. In that inquiry, we heard very concerning evidence about the role of independent children's lawyers. And when we drilled down into, so basically we were hearing that not necessarily, it wasn't always the case that a child's views were being conveyed by the children's lawyer.
To the family court.
And when we drilled into it, we found out that the training for these lawyers was really quite minimal. So 5 years experience in child protection matters, but not as a representative of a child. Some online training, and then a one-day course where some mention of DV and sexual assault was covered. In other jurisdictions, they do require the representatives of children to have a significantly more experience. Is this an issue that you've looked into? Do you have any interest in trying to, extend the training requirements for independent children's lawyers?
Well, the answer to your second question is I certainly have interest in looking at it, but I'll have to take the matter generally on notice.
Thank you. I'll hand back to you for a minute if I can.
Certainly.
Only if you want.
Yeah, no, absolutely. Mr. Attorney, just returning to that issue about whether or not early guilty pleas are falling off a cliff or are being reduced, I have heard from some judicial officers in the local court that this is in fact happening. So I just give you that sort of feedback so that that might inform Mr. McKnight's queries and just to see whether it's actually happening.
But I guess, though, in the end, we'll need to look at it statistically rather than
of course
anecdotally. But thank you for that feedback.
That's okay. Ms. Boyd, are you?
Yeah, thank you. I wanted to ask you about court appointed questionnaires, so the people who are asking questions. For example, on behalf of perpetrators, accused, people who are accused of domestic violence, being able to directly cross-examine victim survivors. The feedback that we've been getting on this is that the court-appointed questionnaires are not necessarily working particularly well, in that they don't really have much training, and that they are also, being exposed to quite traumatizing content and not having any real support for that. Can you give us an update from your perspective on how this is going?
Sure. So we did a pre-budget announcement to fund court-appointed questioners who will be different from those doing it at the moment. So at the moment, it's largely court officers who are doing it, who don't like doing it. They don't like getting involved. They don't like also that because they're court officers, the questions appear to a complainant to have the imprimatur of the court. So we're moving away from that, where we will have a hybrid model. We'll have a team of trained departmental officers who will be court-appointed questioners. There will also be a panel of justices of the peace who will be court-appointed questioners. At courthouses where there is a large volume of this sort of work, we will probably have resident JPs doing this who are trained. At other courthouses where there may not be a sufficient volume of work to keep someone there full time, there'll be a kind of flying squad of departmental court questioners who will go to those courts. There's also, and just related to that, an expanded audio-visual link program where I think we're upgrading or installing about 50 AVL facilities in courthouses in the next financial year.
Thank you.
I just asked Mr. McKnight whether there's anything on the hybrid model he wants to add.
No.
Say anything about the training?
Still
So you
being
want-
developed.
sorry. Just say something about the training, perhaps.
Yeah, so we are looking at setting up the team by the end of the year. So with fundings come through, apologise for the voice, I haven't been talking the last 2 days. So we're about to recruit for those departmental staff and hopefully have them on board by the 31st of December. But there's an extensive training package in there, and all those issues that you raised around support are part of the program as well.
How many are you recruiting?
I'd have to come back to you on that because we're still going through that process. I think there's around about 6 or 7, maybe 5, I guess, but I will come back to you on that in terms of the dedicated staff. But as the attorney has alluded to, is the fact that it'll be a hybrid model. So we're looking at other organisations, potentially the Justice of the Peace as well. So that's who we've been liaising with at the moment.
So it's still in a stage of development. So
That's absolutely correct.
Yeah.
So that as the attorney suggested, told you, we have been working with court staff at the moment who are probably not as happy about doing this role. So we're looking at people who are dedicated to it with the right training.
Thank you. That's very useful.
Thank you.
Do you have any more?
Not that I'm ready for. You go.
Mr. Mosselman, do you have
All
further
right, can I ask
questions?
a question?
I only know because we collectively still have 7 minutes left. If we wish
Okay.
to go.
Just a quick one, if I may, Attorney. During COVID, there were significant delays in New South Wales court systems and there was significant backlog. What is the current status of the backlog in criminal trials in New South Wales District and Supreme Courts?
Sure. Just bear with me a moment. Sure.
We've got 7 minutes.
Yeah.
It's not like a football match where I'm being slow to get the ball when it's gone out of play, anything like that.
No rush.
So in the case of the District Court,
Yep.
the pending trial caseload had reached a peak of around 2,039 in 2016. We got it down to 1,399 in 2019. It's now at 1,466, so it's a bit above the pre-COVID bottom, if you like, but well, much better than 2039. The time taken has crept up a bit. Oh no, I'd say it's probably stable. The median time in days for committal to outcome is fairly stable. Time for justice, we tend to be, the latest ROGS report of Government Services report for 2022, it's a little bit out of date, but the most recent year for which it reports shows us at 66.6% for cases finalised. No, that's civil. Sorry, you asked me about criminal. 75% of cases finalised in less than 12 months for criminal non-appeal in New South Wales. That compares with 66.9% in Victoria. So that's the district court. And the local court, the local court. Thanks. You got the, no, there's a table like this. Just for, thanks. So the local court, the most recent year, which is 2020-21, we had 77.8% of cases, criminal cases, finalised in less than 6 months. That's 77.8%. That compares with 44.2% for Victoria. There has been an increase in the time to justice, but that is now and the number of cases pending trials is now slowly reducing.
Attorney, I'm interested in particular with the 1400 mark that you've indicated that the last hearing where you anticipated it would take a year to reach the pre-COVID figure of 1400 in district court. You're still currently above that, isn't that right?
That's correct.
What's been the reason for the expected, for the delays?
Well, twice now COVID has seen a suspension of jury trials. It wasn't possible at the worst times of lockdown to have jury trials. And then when jury trials recommenced, it was necessary to have more space for them, different arrangements for impanelling juries, in some cases using courtrooms as jury deliberation rooms for social distancing purposes. So that disruption has been the reason for the backlog increasing. But I might say, I think the Chief Judge and his judges have done an extraordinary job in managing that backlog. You know, when you think that the courts were closed for months and the backlog has increased only in a fairly modest amount, I think they've done an extraordinary job. And the current Chief Magistrate and his predecessor also in the local court.
Same reasons apply for regional courts?
It did, but I think regional courts in some cases reopened sooner than metropolitan courts because of different COVID restrictions in the regions compared with
funding issues are not issues of delays?
No, not at all. No. So, you know, we've 7 extra district court judges a couple of years ago, and this year, to help get that backlog down even further, there are 3 additional district court judges being appointed for 12 months. But to avoid any controversy about appointing acting judges who are auditioning for permanency, what we're doing is, and the recruitment process is underway at the moment, the advertisements have gone out. I think the interview panel has either met or is about to meet, appointing 3 permanent judges almost straight away in the anticipation that 3 existing judges will retire, you know, sometime during the year. So that's how we get our 3 extra judges without offending people by using acting judges auditioning for permanency.
I'll hand over.
I'll hand the chair and the questioning back to Ms Higginson, noting that I took some of Ms Boyd's time earlier.
Thank you. And just to note, I'm informed the government aren't going to be taking their 15 minutes. So this will take us to the duration. So
thanking the Minister, what a great job he's doing.
Yeah, well, that's right. I must say it's very civilised in here. Okay, so Attorney General, this crosses a little bit in relation to corrections. However, I have thought about it and I do think this is a matter for you, but you let me know otherwise. So more than half of people that are leaving prisons in New South Wales return within 2 years. There's an enormous body of evidence noting the importance of addressing all the social drivers of incarceration to reduce recidivism. Are you able to detail or just outline what funding and the services and programs that you see in the sector as the AG overall that is really going to address this? And the very sort of getting to that heart of recidivism. We talk about it so much across the sectors, but what are we actually doing in terms of those social drivers and the underlying causes?
The detail is probably best addressed by the Corrections Minister, but I'll have a go at some general comments. Certainly, behavioural intervention programs in prison are critical. High intensity programs and those with domestic violence offenders, and having them all empirically evaluated. Support in prison for mental health and substance abuse issues, and some of that will be in the response to the ICE inquiry. And support when prisoners leave, because if they've got nowhere to go, no job to go to, that's when they're most at risk. So evaluating parole, reintegration, home attention are important parts of that as well. So most of those evaluations and the day-to-day carriage are the responsibility of the Corrections Minister. But obviously, locking people up and throwing away the key is not the answer, because they'll get out eventually.
And what about in your role though as attorney? What do you see like the that not once somebody is in incarceration, actually trying to address this prior to? I know the issue is recidivism. However, what about the where are we looking in terms of diversions and reinvestment, I suppose,
Sure.
The holistic. We've seen the evidence. We've seen some of the economic advantages. If I can just point out and remind us that, we are spending $1.26 billion.
Yeah, you're encroaching into our 15 minutes.
Sorry?
I think you're encroaching into our 15 minutes.
Oh, I thought you said you didn't want to.
No.
Oh, my time's up. So, yeah, could I just ask then, if you're open to this, the work of the incredible work of the Justice Reform Initiative with those incredible patrons. It's very new to me. I wasn't aware of the Justice Reform Initiative with those incredible patrons. Are you aware of the...
Oh, absolutely. I've met Mindy and Robert twice, and a third time in passing. And I'm certainly aware of the broad multi-partisan spectrum of patronal support.
And do we share their laudable objectives?
Well, I think we all want to see reoffending reduced. In terms of what happens before someone goes to jail, that's why we reformed intensive corrections orders in 2017 to avoid prerequisites of mandatory work when people either can't find work in regional areas or have mental health or substance abuse issues that preclude them from that. So we've seen rates of intensive corrections orders increase, and Boxar established that in a report a couple of years ago. So that's very important. Our driver disqualification reforms, where I think we've seen something like a 1/3 reduction in the number of Indigenous people who are incarcerated for driving without a licence or while disqualified. Very important reforms. Alternative pathways for Indigenous offenders with trialling the Wallumbilla Court, youth Koori courts are important as well. Alternative pathways for those with drug addiction issues with the drug court, they're important as well. So I could go on, and not just in the justice system, but it's important. I mean, it's a whole of government response to get offending down. By the time someone is offending, they have had either childhood trauma or education issues or substance abuse issues or mental health issues. So addressing those things is probably more important than what we can do in the justice system, without suggesting that there's not plenty we can do in the justice system.
Thank you.
Yep. Thank you, Chair. Good afternoon, Mr. Attorney. Thank you for your very impressive and polished contribution today. Before we break for lunch, was there anything you wish to share with our committee?
No, unless you think there's anything I should clear up or...
No, it's too polished. You can't add anything further. So thank you for your time.
Thank you, Attorney General Speakman, for attending the hearing. We are finished, and the committee will now break for lunch and will return at 2 p.m. for further questioning. Thank you, everyone.
Thank you.
time. We've reconvened and we're back. So thank you, everyone. And it's over to the colleagues on the left. Thank you. The opposition.
Mr. Tibble, Mr. McKnight. Perhaps unusually for this hearing, I'm going to refer to budget paper number 2. Look, I think somebody has to do this at some stage of the hearing, just, as it is budget estimates. If you've got it, this is just so you can read along with me. Page 8-10, this is about the key performance insights. And I just had some questions about what's in the budget paper and just happy for you to explore a couple of things. So I know this was touched on briefly with the attorney, that the percentage of local court criminal cases finalised within 6 months remains challenging. And I think on the last occasion, looking at the transcript, we were talking about the buffetings of COVID, and then of course there was the flooding, particularly on the North Coast, and there was a general dislocation, that the courts were dealing with. So what I was interested in was that part of the page I've just referred to, where it talks about the court making efforts to reduce the backlogs and is considering appropriate measures in consultation with partner agencies and stakeholders. I was wondering what other measures were being considered for implementation in the local court to assist them dealing with this increased backlogs. Because I think I can see the chart and the backlog has stabilised. I just wanted to sort of see what the measures that the court was considering implementing.
Mr. Searle, I meet with the heads of jurisdiction on a regular basis, and there has certainly been a very active dialogue through the course of COVID, but even through the course of the floods in recent times, where the work of the courts was disrupted, but pleasingly recovered in terms of operation quite quickly. So there is a close collaboration. There is a constant focus on efficiency, but obviously without diminution of service. In terms of the challenges of the backlogs, given that there is a forecast recovery time, the moving to that point obviously is a focus. What I might do, though, is in terms of where those discussions are currently at, is refer to the Acting Deputy Secretary, Karen Wallace.
Hi there. So I guess the thing with the local court, and I apologise again for my voice, but at least I've got one today as opposed to yesterday and the day before.
Well, this is all, we're winning.
Thank you.
The local court has recently had an extra 8 magistrates put on. So I think the last time we met, there was still a number of magistrates outstanding. So now we've got 149 magistrates on the bench. And prior to June, we had put on a number of acting magistrates as well to help through the backlog. When we talk about recovery, I think that we need to mention that, and I don't know if this has happened in Parliament or not, but we've had a lot of sickness as well. So it's not only just been COVID, but infections as well. But what we've looked at is, if I talk about the pending defendant matters in the local court, it is really still quite high. So we've got 27,669 pending defendant hearings, of which 10,112 involve a domestic violence or offence or an application. So, but we're currently reducing that pending, that we are continuing to reduce the pending caseload. I know that the Chief Magistrate has been working closely with our partner agencies to work at options to reducing that backlog. So I think that we've got a couple of things there. Firstly, the additional magistrates, and also the other costs that are involved in that. So extra funding for legal aid and DPP have helped, as well as staffing. And just working closely with the partner agencies. But I still think that we have got a long way to go. And in our world, we really haven't, we're only just stepping out of, the COVID world. We did go back to masks recently with the increase in infections in the community.
So what? Just refresh my memory. What is the backlog now for the local court?
If I have a look at it, it's taking around about 22 to 23 weeks in some locations to get a hearing date. So it is
These
taking
criminal matters, or are they civil?
criminal
now?
matters. Yeah, criminal matters. Yes.
So what's the civil?
I don't have the civil. I'm
Okay.
sorry. We have such a small civil workload in the local court. Only about 2 to 3% of matters go to the civil. When I talk about civil, I mean default matters and all those sort of
Yeah,
things.
but I mean, contract
AVOs
matters.
are included in the criminal space for the purposes of defendant hearings.
Do you have a regional breakdown of the backlogs? Like
That is
Greater West?
that is possible to get. I don't have it.
Okay, if you could on notice, Mr. Tibble,
Yes,
provide
certainly, Mr.
a
Saul.
geographical breakdown
Yeah.
of the criminal
Yes.
backlogs. And I understand that the civil jurisdiction's quite small, but I understand there is a...
Yep.
Yeah, there is. There is.
There is, I mean,
But let me say the Chief Magistrate has been working towards redistribution of resources as well as working.
Of course.
Yeah. Okay.
So we've got the additional magistrates and the additional funding for legal aid
Yes.
and other things. But when the budget papers talk about considering other appropriate measures, those measures are very much still being formulated for implementation.
Correct.
Okay, that's good. So it's work in progress.
Well, what I can say is that there is going to be, subject to everything staying the same,
Sure.
that the time to justice will fall during 2022 and 2023.
Sure. Okay, well, that's good. In the following paragraph, of course, you mentioned the additional magistrates, which increases the capacity of the court, and that'll drive down the backlogs. It's mentioned there, further ongoing investment in court digitisation is expected to continue to deliver productivity gains and assist in offsetting growing caseloads. So what is that ongoing investment in court digitisation? How much is it, and what is it being spent on, and how do we expect that to assist in dealing with matters expeditiously? I mean, I assume part of it is, the usual technology we currently have to do, online matters as occurred during the lockdown, but maybe there are other things as well.
Yes, if I can break that perhaps, Mr. Searle, into two parts. So is the work coming out of the 20 budget in 2021, which kickstarted or progressed the digital reform program, but all to do with a 3-year work program which is now underway, started or carried through under the New South Wales Digital Restart Fund with the following outcomes: online lodgement and new modern digital applications for all jurisdictions, replacing approximately 450 paper-based forms, the implementation of the DCF, the digital case file, which will enable parties to provide court documents and evidence electronically and remove the need to attend registries to lodge, the movement of courts to common platforms and the extension and the life of justice link, increased court capacity and judicial efficiency improved by enabling small matters to be resolved online, and of course the reduced number of physical appearances. But rolling forward to priorities for 22-23, the program has prioritised implementation of the following across courts and tribunals: use of a DCF in civil matters in the Land and Environment Court and selected locations in the District Court, resolution of procedural matters for summary offences where there is no bail, such as requests for adjournment online rather than by physical appearance for matters listed at 5 locations, namely Burwood, Hornsby, Newtown, Wyong and the Downing Centre, with expansion to other locations in future years, digitisation for NCAT and transition to a single case management system, digitisation of the probate application process in the Supreme Court, including issuing a digital grant of probate, additional forms to be digitised in the IRC, and finally pilot of an electronic diary in the local court to replace the use of paper-based diaries in the courtrooms in that jurisdiction.
It's a pretty ambitious reform agenda.
It is indeed.
It is indeed. Okay. And is the ultimate objective at some point to have all the courts and tribunals on sort of common technological platforms for things like filing of initiating processes and evidence and the like?
At the moment, the case management system that we have in courts and tribunals is a common platform, except for NCAT, will be by December. We are working closely together to make sure that that what you learn in one jurisdiction can work in the other jurisdiction as well. It makes sense for us, particularly as you know, with regional areas that we have. At those courts, we sit all jurisdictions as well, so it makes sense for us to be on the one platform.
Oh, absolutely. I mean, I think even before I came into this place, the federal court was accepting, initiating processes and affidavits to be filed electronically. You'd get the little court seal in your email, and obviously the state courts haven't had the same level of attention until now, perhaps. All right, well, that's very good. In relation to the following page then, page 11, which talks about the district court, it mentions, again, the greater use of technology to drive down the pending criminal trial caseload. Is that the same set of technological solutions, Mr. Tidwell, that you just addressed in the 22-23 work?
My understanding it is, and I'll just confirm that with Ms. Wallace, it is.
Yes.
Okay. All right. And so what are the criminal and civil backlogs in the district court at present, as we are emerging from COVID and the floods and the...
Do you want me to do it? Yeah. The district court criminal caseload is 1,466 pending trial matters, and it's decreased from 1,624 in December 2021. So it's going down, which is good.
Almost back to pre-COVID levels.
Yeah, almost back. We've got a little way to go. We're looking at being at pre-COVID levels by about between Q4 23 and Q4 24 for the criminal matters. I don't have... Can I come back to you on the civil ones?
Of course, no. Again, this is not a gotcha moment. I'm actually genuinely interested in the answers to these.
Yeah.
And so if you can't answer, yes, please provide the information
I will.
on notice. And additionally, if you can, a regional breakdown.
District court, we should be able to do something along the lines with the district court,
assume,
but I'll have to take that on notice.
like the local court, the district court still has circuits, I think, in different parts. So I assume you'd be able to provide the information for those circuits, if not...
Happy to do so.
Yeah, that'd be good. Alrighty. Not that it's sort of mentioned here, but how's the Supreme Court tracking in the wake of COVID? I know they were also hard hit by not being able to do in-person hearings, particularly in defended criminal matters. So how are they recovering?
Do you want me to take that?
Yes, thank you.
Okay. So as at the end of June 22, the waiting for a 4-week criminal trial was 5.6 months. So that's an improvement from the waiting time at the end of June of 7.5 months. And so the number of pending criminal trials has decreased by 6% since June 2021. So they had, just because we're into stats, as at June 22, there was 141 pending cases, and the number of pending civil cases overall has increased by 5.5%. So they've been dealing with the criminals have dropped, but the civil has increased by 5.5%.
Okay. And as well as the number of pending cases in the civil jurisdiction increasing, is it taking longer to get to those civil matters as a result of maybe prioritising the criminal matters?
I'd have to take that one on notice.
Okay, if you could take that
I
on
can
notice.
respond. In respect to civil matters,
Yes, please.
the waiting time for a civil appeal has increased to 2 months at the end of June.
Okay.
And from zero,
What about it? I mean, I know it probably mainly deals with appeals, but they presumably still have some action in the original jurisdiction on civil matters. Anyway, if you have some stats on that that you can provide on notice, that would be useful as well. How's the Land and Environment Court tracking again against those sorts of reporting stats? I know they've got their class 5, which is their criminal matters, and then of course everything else.
There's I can give you overall figures in a moment, but there's two areas that I concentrate on, which is the Class 1 proceedings and the Class 5. The Class 1 proceedings, they've increased but remain below pre-COVID levels. And the criminal prosecutions Class 5 matters have increased to historical high levels, and that's got a backlog of cases. But as at June 22 overall, the pending trial caseload for the Land Environment Court was 1107, which was a slight decrease from 2020. So you can see within the Land Environment Court there's bits of ups and downs between the Class 1 through to Class 8s.
So overall, is the workload of the Land and Environment Court increasing, or is that just attributable to the COVID delays?
I think that one of the things is that within Land Environment Court you've got sort of short matters and then you've got sort of long matters. And so the Class 5 matters, which are more complex and a bit more judicial, they have increased. But they seem to, I mean, it's overall that there's been a slight decrease, but I can drill down into it for you if you like.
Okay, that would be useful and interesting. So how many judges and commissioners are on the L&E Court? It's what, 6 judges and...
There's definitely 6 judges.
And how many commissioners?
We've just put on another 2.
I see the budget papers talks about another 2 commissioners in 23-24. Has that been brought forward to this year, or is that another 2 that'll be put on next year?
I think that they were, there was 2 that were on and have been extended, as I understand.
They were appointed, I believe, in September 2019. And 4 new acting commissioners are appointed for a period of 12 months in April 2020.
Okay, so they're additional but temporary.
Yes, on the 9th of November 2025, new acting commissioners are appointed for a period of 3 years.
Okay. Have they been extended, or are they still
And on
ongoing?
the 14th of October 2021, 5 new acting commissioners are appointed for a period of 1 year.
Okay, all right. That's good to know. All right. How are we going? 3 minutes. All right. Well, I might ask some questions about victims' services, just to change gear. Can you provide an update on the review of the Victims' Right and Support Act 2013, where that process is up to?
Yes, indeed. So can you just repeat the question, Mrs. Hall?
Certainly, the review of the Victims' Right and Support Act 2013, where is that review process up to?
I'll ask Mr. McNaught to respond.
So an issues paper was released earlier this year, and we are now getting submissions on that. If you give me just a second, I will tell you where we're up to with considering those. Where are we?
Look, I'm happy to start talking to this if it will assist the committee.
Please.
So the review, as Mr. McKnight has indicated, has commenced. The department publicly released a background paper inviting stakeholder feedback on the Act via the New South Wales Government Having Australia website and the DC website on the 29th of April 2022. Written submissions on the paper were due by the 11th of July. There may be further stakeholder consultation as part of the subsequent stages of the review, including in relation to potential options for reform. The report will be tabled in Parliament within 12 months of the review being completed.
All right. Anything to add, Mr. McKnight, or is that?
No, just that the submissions being received will be being analysed at the moment by the policy team who are conducting the review.
I mean, not that there's any obligation to do so, but will those submissions be published online so that people can sort of see what the issues are that are being...
I'm not sure what the process has been in relation to this statutory review. As a
I mean, they're not usually, but in some cases they have been.
As a general proposition, we do try and publish submissions received to statutory reviews publicly. It's they're open reviews. It does depend on what process we've taken in the particular case and how we have portrayed those submissions to stakeholders, because obviously we don't. We like to tell people that their submission's going to be published if they make it. But as a general proposition in the department, we prefer these processes to be open.
Well, perhaps you could take on notice whether or not they're going to be published, and if so,
happy to do that.
When and where. And I think the question now moves to the chair.
Thank you. Yeah, look, I just have a brief question. It's a bit of a continuation from where I was before with the attorney, and it is just in relation to your department's role with Justice Reinvest programs or projects. Understand it's largely goes to the corrections, but is there something like, are you resourced to be looking at that and that justice reinvestment work? Because I know some of those programs the attorney was speaking about in terms of wraparound, etc., go straight to that justice reinvest.
So if I can answer it in these terms, Ms Higginson, the responsibility, and I look to Anne Campbell to affirmingly nod, but it falls within Minister Ward's responsibilities and is looked after as a part of Ms Campbell's policy remit, where I'm reluctant to use the term best practice, but where a range of potential reforms and policy directions are pursued. It certainly fits within that part of the DCJ remit. And we, of course, as was indicated by the Attorney-General this morning, awaiting the review in respect of the Reinvest program in the final quarter of this calendar year.
And so then just on that, if it's okay, I sort of knew there was an intersection of some sort and that we were... so from where you view that work and how it's looking and the inquiries and investigations we're making at a departmental level in these initiatives, do you see that we are likely to edge towards a big investment in that work, or is that where we're looking in terms of the evidence of the success of those programs, etc.?
I think we need to see the evaluation first, which is due, as the Secretary said, later this year. So I think once we've seen was it effective, did it do what it was intended to do, government can then make a decision in relation to that.
Thank you. And so you're saying that's the particular project from Burke, or are these specific on-ground example programs that are being evaluated?
So you're talking, I think, on a different topic.
Okay.
So in terms of the justice reinvestment, there was an announcement recently by the attorney of an additional $9.8 million. There are existing programs that obviously are operating. So there's the Marinuka Justice Reinvestment Project out in Burke. And the government's provided the following funds to that program. So I won't go through that because I think you're probably across that detail. And the key minister that's responsible for championing, they call it a championing minister, is the New South Wales Minister for Health. And he recently committed $320,000 for the second year of funding for this project under the Commonwealth Stronger Places, Stronger People program. And that funding will be administered by Department of Planning, Industry and Environment. And in addition to the recent financial contribution, the government works with this program in a variety of ways. So there's a cross-sector champion, which, as I said, was the Minister Hazzard, Minister for Health, and a cross-sector leadership group that comprises senior leaders from all levels of government, non-profits, philanthropy, business, community, etc.
Thank you. Please.
Sorry, just for the sake of clarification, there is a real trick here with aligned terminology, and I just want to be very clear. There is the Reinvest treatment program in respect of sexual violence, which is subject to evaluation, and I've said due between now and the end of the year. I believe your question, though, pertains to justice reinvestment. So I just apologise if we have.
No,
confused
that's
those
absolutely
two.
fine, because naturally that's a key area too of interest. I mean, it really, where I suppose I am getting to is where, and I think it is a broader kind of direction of the department and the sector and where we're heading in terms of that reinvest. So yeah, I mean, thank you very much. Do you have anything else that you would like? Because I'm not too fast.
I've got some questions.
We've got some more questions coming. Thank you.
Thank you.
Yes.
Mr. Timble, I think during questions with the attorney, I handed up a letter that the attorney had sent to the community legal centres, and in the third paragraph, towards the end of that sentence, there's the reference of $2.2 million per annum government funding for critical service gaps, to which indexation would also be applied. I'm told that there is a delay in the delivery of that money to community legal centres. I just wanted to see whether that understanding is correct, and what is the cause of the delay, and when will the money be delivered, if that understanding is correct.
Mr. McKnight.
No.
Sorry. Oh, Visito from Legal Aid.
Of course.
Mr. Searle, I'm not entirely sure I'm able to give you an answer to that question, so if I could take it on notice,
Of course.
that would be,
as I said,
I think, good.
just after the information, so
Yeah.
if you take it on notice, that'd be really good.
Thank you.
Alrighty. So I've got some detailed questions on victim services. We'll see how we go, and if it becomes a theme of you having to take it on notice, I might just put them as supplementary questions. But let's see how we go. There's a number of different aspects of victims support. For example, there's counselling, there's financial assistance, immediate needs, financial support, economic loss, and recognition payments. For each of those aspects, can you tell us how many applications have been received, have been determined and awarded, or are pending, or lapsed or dismissed in the last financial year, that is from 1 July 21 to 30 June 22?
I don't have them in front of me, but they're about to be produced for the annual report.
Okay.
So we are going to have very more detailed information
Okay.
that you've been seeking.
Okay, that'd be really good.
Okay.
We'll maybe take them on notice.
I will.
And you can provide them to me, even if it's...
I do have some information
Okay, well-
here, by the way, that I can just say to you, is that in terms of application by support type, if this meets what you're required, recognition payments we had at recognition applications is 15,207 for 21-22. That was up from 13,155 from last financial year. Financial support applications were 9,388 applications compared to 8,613 last year.
What, 12.5% increase?
I'll go with you on that one. Counselling was 22,741 compared to 18,978. And total applications, so there was an overall of total applications. There could be multiple support types of 29,131 compared to 24,205. But as I indicated to you, we will be providing further details in the annual report.
Okay. This is not a gotcha moment. When do you expect the annual report to be available?
I did inquire about that. I think that it's due at the end of October, tabled.
Okay, so you can answer on notice then. So in relation to those different components, do you have that breakdown by gender and age of applicant?
I would have to take that one on notice.
Of course, yeah, no, that's good. I mean, I'm told that kind of data was published in 17-18, but when I asked the question in March of 21, I think the answer was the Department of Communities and Justice doesn't hold the information in a readily accessible format. So I was just wanting to see whether you still have that information in that format or...
Yeah, I do know that the team have worked on producing a whole lot of information that will be presented in the annual report. What I intend to do is to let people look at that and see if there's particular areas that are missing from it. So we've done the high-level stuff around it. There's subsets of it. Take that on board, and if there's information that's missing, we'll see if we can access that information.
Okay. And by the same token, just as my question was, whether or not that information will be broken down by gender and age, will that information also be broken down by the number of Aboriginal for Torres Strait Islander people who are
yes,
applicants?
It will be.
It will be. Okay, that's good. Okay, that's very good news. So in 21-22, that is the financial year just gone, what was the average payment for immediate needs?
I can indicate that the total amount awarded in 21-22 was $27.2 million, including, in respect of economic loss, $2.1 million and $400,000 of funeral costs. For immediate needs, $24.8 million awarded, including $24.8 million awarded.
So that's for immediate needs, including for funeral expenses.
Just repeating that, no, funeral costs were under economic loss.
Okay. So 2.1 million for economic loss?
Correct. Economic loss 2.1 and immediate needs 24.8.
24.8. And that's by...
And a total, an aggregate of for counselling, which I should add, 22,481 applications approved and some $27.9 million is paid.
Okay, so we can do the maths based on that. And what about recognition payments?
Recognition payments, there were 28,778 decisions and $60.9 million awarded in the year 21-22.
Okay. So in terms of applications for financial assistance, for immediate needs, for financial support, for economic loss, recognition payments and counselling in that financial year,
Yep.
What is the shortest time to make a decision, that a decision was made? What was the longest? I guess we can work out the average from those.
In terms of service standards, and I look to Ms. Wallace to correct me if she has a different understanding, but applications, starting with applications are registered within a day of lodgement. Counselling applications are then determined within 1 to 2 days. The average waiting time for calls to the Victims Assistance Line is under 2 minutes, and the median time to determine recognition payments has increased. Median time in determining recognition payments, I actually don't have, I can't quantify that here.
That's okay.
I actually don't.
Well, maybe
have
I'll put that on as a supplementary and we can follow that up. But I'm happy for you to provide the answers to those things on notice as well, if you can. How many applicants have responded to the client satisfaction survey for that last financial year, 21-22? And how are they selected to respond? Is it generally open to every client, or are they sort of selected on basis?
I'm unable to assist. I could come back on that, Mr. Searle.
That's fine. I mean, happy for you to take that on notice. Do you have any stats on how many people actually attended the counselling appointments that were approved for them? I assume people mostly use up what they have been approved to do, but I just wanted to see if there was any issues in regard to that.
I do not have them with me here, but
That's
I'm
okay.
sure we could provide it.
Okay, that's useful. By the same token, can you let me know or let the committee know how many applicants actually accessed counselling and how they accessed it, whether it was by phone, by video or in-person appointments in that last financial year, 21-22? How many counsellors are located in each regional, rural and remote area, along with the clients they assisted in that last financial year? How does it work? Do you fund the private sector counsellors, or do you have a number of counsellors on your books? Is that how it works?
Yes, I believe so.
Okay.
They're listed on the website. Yes. So, but I don't know that level of detail, so it looks like I'll have to take
That's okay.
questions on
As I
notice.
said,
Thank you.
I just get to ask the questions,
Yes,
and if
sorry.
you can't help, and you get to come back. How many new victim services approved counsellors were appointed in 21-22, and where were they located?
We would need to take that on notice.
Okay. What is the total number of victim services approved counsellors and location?
Similarly, I just don't have the data
No,
with
no,
me.
that-
Happy
that-
to take it on notice.
That's fine. Can you tell us the average waiting time between a counsellor being contacted and the first available appointment in which they see a client? Or I guess that's the average waiting time for a client to see a counsellor.
Notice. We'll have to take that on notice.
That's okay. Okay. Can you tell us the number of applications for counselling where the victim survivor is located in a correctional centre or a youth detention centre, including the number approved and the number of applicants who receive counselling? Again, on notice?
On notice.
That's okay. And can you also tell us the number of percentage of applications for counselling made more than a decade after the alleged act of violence, and the number and percentage of these relating to domestic violence, sexual assault, child abuse and child sexual assault? Again, I assume you'll be answering those on notice.
Notice, yes.
Madam Chair, do you have questions yourself? Given the granular level of detail that I'm asking for, it might just be easier if I put them on the notice paper as supplementary questions for you to come back. Otherwise, we could be here. I mean, it's very satisfying in one sense to run through. It means I don't have to type them up, but I think it just might be a better use of anyone's time. Okay. Unless there's any objections to that course of action.
No, I think.
Do you have any questions, Mr. Musselman? Oh, well, I'll hold my further questions and I'll reduce them to writing. I'm sure you'll be relieved to hear.
Yeah. So I think this is looking very much like we may be finishing up. Does the government have any desire to use your final time?
I'll be very brief, Chair. Thank you very much. Very briefly, thank you to the departmental officials for being here today, for your professionalism and your assistance to the committee. Some of you may have taken some questions on notice. Is any one of you in any position to share any information with the committee at this stage?
I am.
Thank you.
Mr. Musselman asked a question about attendance at a culturally and linguistically diverse roundtable, and I can tell you the organisations that were represented at that roundtable. So we have the Chinese Australian Service Society, the Community Migrant Resource Centre, Ethnic Communities Council of New South Wales, the Immigrant Women's Speak Out Association of New South Wales, the Immigration Advice and Rights Centre, Janalwe Family Centre, Multicultural Disability Advocacy Association, Multicultural New South Wales, the Muslim Women's Association of Australia, Settlement Services International, Southwest Sydney Women's Domestic Violence Court Advocacy Services, Sydwest Multicultural Services, and the Western Sydney Migrant Resource Centre.
Anyone else?
Yeah, I've got one. I think Mr. Searle asked a question earlier today in terms of who the provider was for the electronic monitoring.
Oh, yes.
It's the name of the company's Buddy. They're the provider who lease equipment and systems to Corrective Services New South Wales.
And that's BUDDY, or is it IE?
BU, let me just double check.
I think it's BUDDI.
Yeah.
Oh, interesting. Yeah. Thank you very much.
Thank you. So thank you, government officers, for your attendance today. The committee secretariat will be in touch in the near future regarding any of those questions on notice and any questions for you. Thank you so very much.
Thank you, Chair.
Thank you.